was okay with speaking with the soundtrack, but I figured it might be a little distracting. Welcome to the Silicon Flatirons Annual Content and Intellectual Property Conference. My name is Amy Stepanovich. I hesitate to say I am the new, because I don't know if I can claim new anymore, Executive Director of Silicon Flatirons. My vision for Silicon Flatirons is a center that catalyzes the creation and development of inclusive and innovative law, technology, and entrepreneurship. Our mission includes convenings, much like the one you are at or viewing remotely today, support and embracing the heart of the center, which is our students, many of whom are in the audience, and supporting our community both here in Boulder and Colorado and around the country and the world. Intellectual property and copyright have been a key part of Silicon Flatirons for a large part of our 20-year history, and I'm so proud to be here today and to be able to not only get to host, but also actually watch the content of the conference that we're having. I want to start by just a few quick thank yous. First and foremost to Cristelia Garcia, who you'll be hearing from momentarily and who I get to introduce, to our speakers, to our moderators, to our supporters, to the rest of our faculty, some of whom are in the room, to our amazing staff. A special shout out to Vanessa Koppel, who is back here in the back and who has helped put together the entire event that you're going to see here today. And to the students. If you're a student at CU, can you raise your hand real quick? This is just an amazing turnout. We're going to continue to remind our moderators that a rule for Silicon Flatirons events is students get to ask the first question. And we're really passionate about the students that we're able to host and help prepare for future careers. And so with that, I'm going to turn it over to Professor Garcia to let her intro the conference more formally and to thank her again for everything that she does to make this happen. Thank you.
Hi, everybody. Good afternoon. I'm Cristelia Garcia. Welcome to the 6th annual Content Conference now, hosted by Silicon Flatirons here at Colorado Law School. It has been such an amazing opportunity for me to host this conference every year in its various iterations, coming in first as a brand new law professor out of the music industry, trying to convince people that these were conversations worth having. And now as a nearly tenured professor, I feel so incredibly grateful to be able to run this series and to bring in friends and colleagues and people that I admire to talk about issues and to get together and nerd out about these things. And there's so many people to thank. I'd like to start by thanking Phil Weiser, who started this center 20 years ago now and had enough faith in me to hire me and let me run this, at the time was a new initiative. To our fearless leader, Amy Stepanovich, you just heard from, who demonstrates daily that women don't just do law and tech, but excel at it. And I think that's excellent for our students as well. And of course, the peerless staff at the center, Vanessa Koppel, Heather Martin, Nate Mariotti, our Symposium editor and master cat herder somewhere here, Jack, there he is. To the extent that anything today comes across as going smoothly or seamlessly, that is owed entirely to their efforts and despite my best efforts. An extra special thank you to all of the panelists and moderators who've traveled from all over the place, really, despite grave risk to their health, potentially, and everything else, to be with us here today, and for sharing their expertise with us. And finally, thank you to all of you in the audience, students, practitioners, community members, and alumni, for your interest and for your enthusiasm and for being here today. And for everyone on the live stream, thank you for joining us. In the end, all of our programming is for you. And I hope that you'll catch up with me throughout the afternoon at the breaks or at the reception and give me your thoughts on what we might be able to do for programming going forward, what sorts of things are working for you or not, as the case may be. I look forward to meeting all of you. The topic, the paradox of today's topic, I think, as I was thinking about introductory remarks, is that it is at once really accessible, right? Like, we all listen to music. And even the non-musicians among us would probably venture to say that we'll tell you if two songs sound similar, and if they sound a little bit similar, if they sound really similar. I think it deceives in its like apparent simplicity at first. It's also really, really complicated. Copyright law, which we'll get into outside of this panel, especially as it's applied to music, is incredibly complicated. Some would say a beast of a topic. Thank goodness for me, because otherwise I might not have this job, right? So it needs to be hard enough that not everyone can do it. Not too easily, right? So it's good job security for me that it continues to be complicated. But music is something that everyone talks about and everyone hears about. So quick show of hands, those of you who've read about Blurred Lines or Stairway to Heaven or the Dark Horse case. All right, so I think that's interesting too, because everyone's heard about it, and if we went around, everyone could give their opinion, right? Yet only a handful of folks, most of whom are assembled here today, have really dug into the nuances of these things. And I think as such, there's a lot of room for misconceptions, for misunderstandings, for misalignments, and we're gonna be working to dispel some of those today, or to figure out which ones we're not able to dispel. In the audience today and via live stream, we have an amazing combination of practitioners, students, academics, policymakers, and importantly, musicians who have nothing to do with any of these things. The point is not everyone here today is a copyright litigator or has any interest in being a copyright litigator, and we think that's a really good thing. One of the primary goals for Silicon Flatirons programming, and for the content initiative in particular, is to bring together different perspectives from different backgrounds in hopes of getting to novel, maybe even optimal solutions or outcomes. It's also a good excuse for me to put on my professor hat and offer a couple minutes of background to help everyone hopefully get the most out of the conversations that we're going to be having today. In a nutshell, today we're going to talk about songs. Under current copyright law, songs are protected by two distinct copyrights, and they're unique among other copyrighted material for that reason, right? So every song has a copyright on what we generally refer to as the musical composition, also known as the musical work, right? This could be sheet music, it could be a lead sheet, but it's the composition itself, and has a copyright on the sound recording. Right, this is what we actually hear when we listen to the song. You can have lots of different sound recordings on a single musical work. Think of like covers of any songs that are popular that you know, but not the other way around, right? You don't have multiple works for a sound recording. Sometimes these things, like I said, are memorialized as sheet music. Sometimes it's a lead sheet, which vary greatly in terms of how detailed they are. It might interest you to know that the owners of a musical composition and the owners of a sound recording, in some cases, maybe even in many cases, can be and are different parties, right? That that's not necessarily the case, that the sound recording owner is the publishing owner. You can easily infringe a musical composition without infringing a sound recording of that musical composition, right? All of these sort of nuances come into play here. Also importantly for our purposes today and some of the cases we're going to be discussing, copyright law didn't initially protect sound recordings. As a consequence, we have sound recordings fixed prior to February 15th, 1972, which are for the moment subject to whatever state protections are afforded them, but not under federal law. Registration of a copyright, which isn't required but is highly encouraged, requires the deposit of a copy with the Copyright Office for a musical composition. This means the sheet music or the lead sheet, but we'll see today how these facts impact everything from evidence to burdens to jury instructions to objections to verdicts, right? Because this is a significant difference here in the way that they're treated. So we're here today to discuss what at first blush might seem like a really niche topic, right? Substantial similarity analysis of, in music infringement, but which is actually a topic that I believe raises a series of much broader themes. Applicable questions about the proper role of experts and their limitations, for example, burdens of proof and who best bears them, when and why. Policy goals as we apply them to individuals of different categories and to third parties, and distributive justice concerns that are raised when the law applies differential treatment to otherwise similarly situated persons. So I feel like these are more universal inquiries in the law that are really come out in the conversations we're going to have today. Our first panel today will start, I think appropriately, with the music itself, right? We have assembled here working musicians and musicologists who will offer their perspectives on the process of creating music. right? Not something a lot of lawyers spend a lot of time thinking about. Our second panel will feature policymakers of various stripes sharing their thoughts on what is and isn't working, and how any suggestions for how it might improve. And finally, our last panel will feature some high-profile litigators and academics who are really working in the thick of it to help us see what they see as the biggest issues to be solved or to be more properly understood going forward. We'll take some brief breaks in between the panels. There's some snacks and drinks in the room next door if you need them. And afterwards, we will have a reception in the same room. And I look forward to meeting many of you then. So without further ado, I would like to introduce our first panelist moderator, Professor Joe Fishman from Vanderbilt Law School. In addition to being an expert in the legal subject matter that we'll be discussing today, Professor Fishman is himself an accomplished musician. In addition to his JD, he holds a bachelor's degree in music and a master's in musicology. So he's perfect to handle this panel. And without further ado, I will turn it over to Joe to introduce his panelists. Thank you.
All right, thank you very much. Thank you very much, Celia. I teach in Nashville. In Nashville, one of the popular sayings is it all starts with a song, and that's where we're going to start here with the song and asking, what is a song? So we have a wonderful panel here, and I suspect pretty strongly that we're going to have a lot of discussion and a lot of questions. So I have asked our panelists to introduce themselves, and then we will turn to some discussion. We're going to start with the two artists on the panel, and then we are going to move on to the two musicologists on the panel before opening up to broader discussion. So Anna, can we start with you?
Hello, thank you. It's an honor to be here. I'm so excited about being a part of this discussion. And since being asked to be on this panel, it's been all I've been thinking about. But my name is Anna Morstead. I'm actually a part of the Denver music community and been writing songs since I was like a teen and have been in bands for the last 14 years, both as a sideman and a guitar tech, and now leading my own project, which is called The Still Tide. And I'm the lead and primary songwriter for that and front woman of that project. Thanks for having me.
Hi, everyone. My name is Jeff Prostowski, and I am one of the founders of a band called The Low Anthem. We're from Providence, Rhode Island, and I've been playing music and writing songs for 15 years and touring. Toured all over Western Europe and all over the United States with, we got the good fortune of being signed to None Such Records, which was a subsidiary of Warner. And so we were able to tour with Lucinda Williams and the Avett Brothers and the Chieftains, and we opened for Bruce Springsteen and all this kind of red carpet stuff. And then I've also had the experience of getting dropped from a major label and then holing up in Providence at in an abandoned theater where we lived and worked for the last 7 years and made it into a music venue. So I've had been on the side of a venue proprietor as well as touring musician, and that's where I last saw Anna. Our paths have crossed multiple times in different bands and projects. So happy to be here and be a part of this discussion, and thank you so much to Cresselia, because the other thing that I'm after right now is I am, like many of you, I'm going to be in law school this fall. So and that's thanks to Cresselia, because I called her up and I said, you know, I just had a kid and I don't think I want to go on the road right now. You think there'd be any room for me in this kind of copyright world? And she told me, you can make a valuable contribution to the community as an artist lawyer. So here I am.
Thank you. I'm Alex Stewart. I'm a professor of music at the University of Vermont. I've published widely on popular music in the U.S., Latin American music, jazz. So those have been my research interests. I recently returned from a sabbatical in Uganda, which was a wonderful experience. And I'm very pleased to be here. Thank you for inviting me.
I'm Sandy Wilbur. I am a forensic musicologist. I'm also a songwriter and a producer. And I was the expert in the blurred line case on the side of Pharrell Williams and Robin Thicke, and I've done a lot of work in this area.
Great. So Anna, let's start with you. When you're in the songwriting process, do you ever have the experience of thinking that something that you wrote sounds similar to something else that you have heard before? And if so, do you have a personal sense of what kinds of similarity are acceptable and what maybe aren't acceptable? What's okay and what's not okay?
That's a great question. I'm actually in the middle of writing a bunch of new music, which is, well, I'll get there in a second. But yes, I do. I think there's been times when you're like jamming out on a thing and you're like, wow, I really love this. This is so great. And then you're like, that's totally this other thing that I did not write. That's totally stolen. And then you have that kind of breakdown. But I think part of the joy in realizing that this is the song I'm talking about, actually. Came right up. We'd planned this out. She cued it right in time. So I put that in a song, and I was like, that's odd. That's familiar. But then, of course, like in pursuit of trying to always figure something out new or write something new, I think every time I've recognized anything that was similar to something else, I'd be like, oh, well, that's this thing, which I love, and I'm like, great, thanks. And then try to pull it into your own space, which I think a lot of musicians do. But I guess it's been interesting in writing all this new music recently and having asked to be a part of this panel. I hadn't really thought much about copyright in a greater sense, I guess in the way that we're now going to discuss it. But having been asked to be a part of this panel and writing all this new music, suddenly I got really scared, and I've just been thinking about it the whole time. Well, what if I do this on accident? Now I feel like it's a self-fulfilling prophecy. So in a way, I think the awareness of copyright has affected my writing, just in that I'm more, I guess, in a way I'm worried about it more, which is interesting, which I never have been, because I feel like every time I approach a quote of a song, I'll alter it, and that's kind of an exciting process to be like, oh, well, that's a Beatles song. Well, let's not play the Beatles song. Let's move this into a realm that I'm still working towards making something new. So it's interesting.
And just to follow up on something that you said, so before preparing for being here today, were the cases we're going to hear a lot about today, Katy Perry, Led Zeppelin, Blurred Lines, were those decisions, even the headlines, were those on your radar at all?
To be honest, not as much as I think they should have been, which is interesting. And then, of course, kind of prepping for this and reading the amicus brief for the Led Zeppelin case, which I'd also hadn't read. I was surprised that I hadn't seen that, especially being a part of a pretty substantial music community in Denver and not having seen that stuff before. Those headlines flash, and you're kind of like, oh, I'll never do that. I'll never. You kind of push it off, because I think as a band on a certain level, I think it kind of misses your radar. But then as you grow as a band and as your songs become kind of more viable for the, placed other places, then it does become a concern. So I think that maybe is kind of a growing pain of you're just a little dweeb in your basement writing a song, and then suddenly you're in a studio, and then you're with the producers, and then, then it does become a greater concern as, you kind of grow as a band. So.
Jeff, so similar question. Is this something that you think about at all when you're in the process of songwriting? And do you have a sense of, what the ground rules are, what's okay and what's not okay for you to imitate?
Thank you for the question, Joe. So I'd like to begin by just, starting with where music starts for me, which is it's very personal. So for me, it has to do with me and my older brother. So he was always the biggest music appreciator, but he didn't really play. And I was the musician and the creator. So from the beginning of my musical career, it was always this, okay, I had this idea, play something, and then my brother would kind of be the consumer on the other end of that transaction. So throughout my musical career, I've been tracking the evanescence of all of these third parties that come between us. And it's just been unbelievable in the last 15 years to see how you have all of these different labels. I make something, deliver it to the label, and then my brother buys it from the label. How many labels we've been on, or agents, or clubs, or publishing companies, and it seems so evanescent, everything in the industry. And I'm partly here as well to, kind of represent, it's just the two of us who are, trying to represent all these different artistic voices. And so I'm here to, to also learn more about that, for example, to tell a tale, we were signed by this particular team at an indie label called Washington Square, and then they were bought by Concord, and our team was fired. So you call up one day and you have this point person, and then the next day who signed you, who's been listening to your records, and then the next day they're not there. This is the way that the music industry is, in my opinion, and so it's been, from an artist standpoint, we're looking for things that are durable. You said it all starts with the song. Well, another thing that's been durable throughout my life has been our lawyer. And so the one voice who hasn't changed throughout all of these iterations has been our lawyer. So there's something about the law that is durable through all of these changes. Now let's get to the process here. For me, songwriting is an iterative process. So what do I mean by that? So I mean that these ideas, they kind of go through the function of your mind and creativity, and then they come out, and then you're like, evaluate them, and you put them back in through the process again and again. And it's funny to kind of use these fancy words and talk about it, but I figured, Cristela, could I use your guitar and just show you what I mean? So we're in Colorado. One of my songwriting heroes, John Denver. So let's say you take a song like, okay, so I'm jamming out, as Anna says, and now, how can I make that my own? Well, maybe a first iteration is like, oh, almost Denver. I'm not a pop musician in that way of where I'm trying to write to sell, and maybe that's why I found myself in this old abandoned theater for 7 years, working for 4 years on the record that they said did not sound like the Low Anthem when I delivered it. So anyways, but this is the way, I like to write, just, your influence and so on. So anyways, when I was thinking about how to answer the question, to me that was more, and also maybe I'll conclude with this, which is that there's an old Yiddish proverb which says, for every new song there's an old tune. And I thought that was fitting. So that's all.
So first of all, I want to start putting on my business card that it all starts with a lawyer. I like that. Anna, to go back to you, when you're engaged in songwriting, are you typically writing alone, or are you writing with other co-writers?
but then kind of bring it to the band and we kind of expand from there. But I've been in other bands where I've been writing in a group and as a bass player or as just another kind of voice within that creative process. And I was thinking a lot about this because like we all talk about law on this big level, and I think coming from like, being a little guy, let's say, like kind of thinking about our DIY communities and how this affects them. And I think for bands that aren't really seeing a profit from their money, from their, from their music, not money. Like, I guess where does this kind of come into play, and at what point is like, do we start thinking about copyright and all those things? And kind of within that context, I was thinking about these jam sessions where like other people are bringing in their ideas. And I was in a project where the guitar player brought in an idea that was like a blatant quote from another song, like a lick, a riff, that we didn't recognize. And he knowingly brought it in as this like thing, and we're like, "That's so great, man! You're so good!" And then we like wrote the song, and I think recorded it. It didn't make the record, but it was only after it had been recorded that he was like, "Oh, that's from this other thing." And I was like, "How you can't do that? Like, you put us in such a terrible position that if someone were to come after us, and the band doesn't know about the thing." So I was kind of curious about it from that level, or just even group writing where someone unknowingly brings something in, and suddenly you're recording this as a band, and let's say that song becomes wildly popular, and suddenly you could be kind of coming up against a copyright infringement that you had no awareness of. So I kind of came at it from that angle of like, what happens then? And
Does that affect your process going forward? Having been through that, do you now want to ask co-writers, well, it sounds good, but where'd you get it from?
Yeah, which is funny, and I think kind of on that community level where everyone's really supportive and inclusive, and all these ideas are open, and there's this kind of like all skate feeling of like everyone in together. I think only after that I was like, oh, I didn't realize that I could legally be on the line for something that I wasn't like aware of, which was kind of a confusing and tricky thing. So now in that way, I kind of, and of course, like when you're jamming and someone does bring in something, you're like, oh, but that is that Beatles song. And you're like, oh yeah, haha, and then you change it. There's always the change, I think, in any circle we've been aware of anything that we were imitating accidentally, just because I don't think that we wanted to do that. But that was the only time where I was like, wow, that was, and then it kind of echoes your first question of like, at what point is that imitation like a respectful quote, kind of in jazz where you can quote someone and it's like an honorary kind of amazing feat if you can sew it into these lines. You're like, oh, that was it. But with this, is that like respectful and honorable to quote, or is it just a blatant ripoff and something that we could legally be on the line for?
Have either of you, working in teams, ever had a difference of opinion on that question? Right, you think something's okay and somebody you're working with doesn't, or vice versa?
Yes.
Ever come up?
Do you have a go?
Yeah. I have a little story. So firstly, I really appreciate the copyright law in the sense that I feel like I wouldn't be able to have had all these life experiences if there wasn't this fence around our original compositions, such that there could be a music industry and such that but at the same time, I definitely am critical of it. And I'll tell you just a little story about how it just came to mind when you were saying that, which is that one time we decided that we wanted to put another artist's song on one of our records. And so we called him up and we said, hey, could we use your song? We love it so much. And he was like, sure, of course, no problem. So we went on to record it and then delivered it to our label and said, hey, this is someone else's song. We don't claim that it's ours. And at the last minute before the album was going to be released, he came to us and said, I changed my mind. And he held up the release of the album because we couldn't get this permission. So this copy, it's just a little story, but it really did happen to me. And also to show you about how things can get kind of ugly in the music business, is that he then said that he said, I will only give you permission if you let me open for you on the tour. So he like used that leverage to then, so the music industry, it's, but you know what? But maybe law will be just the same when I go. No, I'm kidding. But yeah, but I wanted to just share that how, you know, and towards the criticism, I think also when Chris Taylor first wrote me the email and said that this was a conference about content, like content conference, I just like, I don't like being content. I just have to say that, you know, part of the criticism, like that's part of the reason why I want to get out of this like, I feel like where the industry is going with I'm sure, okay, how many people use Spotify? Okay. See, so like, I'm not getting paid for this very much, and so I'm thinking, you know, this idea that, okay, I'm going to make another record and put it out there as, you know, as this kind of like, and add to this content where I'm not seeing a return. I'm seeing inconsistent royalty streams, and I'm seeing, you know, people more and more coming to me with other free promotion ideas for me to pursue, and that's really hard, especially for someone like me who's a new father and has other kinds of responsibilities that needs a kind of durability. So, anyways, just wanted to bring that up as well. I know I knew streaming was on my mind and I wanted to bring it up, but I definitely have seen throughout my career. I started back when we were, you know, it was like CDs and CD Baby and all this stuff and Tower Records, and now all the CD stores are closed, and the music industry has really flipped. There was no Spotify, there was no Apple Music when I started. So I've just been like, what is happening? Why is my income going down and down and down and down? And so part of my desire to get into the law is also, you know, I would like to help serve artists and help them accomplish their goals, and you know, because it's really getting hard out there. And again, I'm not speaking towards this. I think that this particular problem that we're talking about today is really a problem when you have the money to hire lawyers and so on, and you're at a certain level of pop music. As evidenced by the cases we're talking about. We're not talking about, you know, some little person, you know, here and there. We're talking about, like, you know, Blurred Lines and Pharrell Williams and all these, like, kind of superstars and whatever. So I just wanted to bring that up as well. You know, who could be sitting in our seats, I think, is maybe, like, someone from the Marvin Gaye estate, or it could be, you know, Robin Thicke or something. Like, it's them, they'd be like, yeah, like, I couldn't get that yacht because of this stupid case, you know? But for us, I think we're providing this different perspective that really is more of a working artist perspective.
Yeah, so much of this is about power dynamics, and I want to come back to that during our discussion afterwards. But so speaking of the cases, that's a good segue to turn to the second half of our panel here. So Alex, let me start with you. You know, if you are a musician or a recording artist, you're not necessarily holding yourself out as an expert on musical similarity, but you and Sandy are holding yourself out as experts on that question. So how do you think about similarity between two pieces, and does it match up at all with what Anna and Jeff have been talking about?
That's a good question. As you probably know, in the law, there are two tests: the intrinsic test, which is the lay listener test, and the extrinsic test, which is where the experts come in, which is supposed to be the objective analysis. And so many of the cases that are presented to me obviously have some similarity, or they wouldn't be approaching me with the idea if they're a potential plaintiff. And I find that well over 90% of these matters, I have to tell them, no, I don't think you have a case. So they're really different tests. I mean, something that sounds similar to the ordinary listener, the average listener, won't necessarily at all make it to the standard of you know, being substantially similar under the extrinsic test.
And so it looks like you have some examples here. Could you walk us through how you would think about, in a particular case, work A and work B?
I have some slides here. Maybe it's a good time to go to them. So I was going to take a look at a case that I was not involved in, which makes it more comfortable to talk about. And this is, of course, the case that's been in the news most recently, Gray v. Hudson, or the case, Dark Horse case, as everyone refers to it. And I'd like to emphasize again, I have no horse in this race. Sorry for the bad joke, but I'm not involved in this in any way. But I'm trying to understand better how this verdict was reached. And so one thing to keep in mind is that these cases are not decided on the music alone. So often there are other factors that come into play, things that happen inside or outside of the courtroom. So I find that at musicology conferences and so forth, everybody's always talking about, well, how could this have been decided this way? You know, the musicology doesn't back that up. And the fact is that there's a lot of other factors that come into play in a trial. How sympathetic one of the parties might be or unsympathetic to the jury. Rulings that are made in the course of the trial, evidentiary processes, and so forth. Now, one of the things that became critical in this case was the access question. You know, did Katy Perry and Dr. Luke, the songwriters, have access to the Christian rapper's song, Joyful Noise? And on the basis of the fact that Katy Perry's parents are traveling preachers, they thought there was a connection to this Christian release that she could have heard it. At least that was one of the main arguments as I understand it. I'm not going to talk about access today because that's not something that musicologists typically get involved in. We're talking about comparing the actual music. And so the first step in comparing the music, for me anyway, is to put it into music notation. But even that is not always purely objective. You'll find that different musicologists will come up with different transcriptions of the same music. So I wanted to look at 4 different depictions of the ostinato that was at issue in Dark Horse. An ostinato is a melodic pattern generally that is repeated over and over. So let's look at these 4. Each note has a articulation to it, has an inflection at certain points in the pattern. So it's do dee 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 da da da. You all heard that, right? So in the defense's expert transcription, he wrote those inflections as actual notes. And if you look really closely, you can see that there are some little lines written there to indicate glissandos, that it's a slide. But it's really not apparent to somebody who was not really paying close attention. It looks so different from Dark Horse, doesn't it? Because of the way it was depicted there. And in the Amici brief that was filed in support of Katy Perry, the glissandos are not even indicated at all. The glissandos in Dr. Ferrara's transcription are there, but you can barely see them. But in the Amici brief, it's not there at all. So that would be do-a-da-da-da-da-da-da, with distinct pitches, distinct notes. But interestingly, the plaintiff's expert, and this is maybe the first case where I've ever seen this happen, didn't use music notation at all. And that really shocked me when I heard that. But he used this chart down here using these integers for each pitch. Own transcription up there with the notes highlighted in red that are the same. and I use those little marks to indicate the inflection. Let's listen one more time to that it doesn't have those inflections, so there was no kind of disagreement over that. How many think the first transcription gives the best visual representation? How about the second transcription without any glissandos at all? Figures, Dr. Freundlich. My transcription? Yes! And then how about the plaintiff's expert transcription? Yeah, okay. But I do this really not to, again, like I don't want to beat a dead horse here, sorry with the horse jokes. But I'm just, this is what we do as experts, is to try to put it into some more objective framework rather than just, oh, this feels the same, it sounds the same, it's the same groove, which can mean a lot of different things. One more quick thing, I had some other things to talk about, but let's listen to the rap section in Katy Perry's song. What do you hear during these sections of these songs, which comprise, like, in the case of Joyful Noise, that's the majority of the song, almost the entirety. And in Katy Perry's song, it's a very substantial part in the center of the song, the rap section with Juicy J. What do you hear besides the rap? We hear drums, we hear ostinato, we hear the rap, and then we hear some sort of ambient grunts. That's it. That's the entire track. So I want to just...
Quality of the instrument that are playing those notes, or does that not enter into your thinking?
To me, if the notes are similar, then we also look at some of these other aspects because they're part of the composition as well. Mm-hmm. But obviously, I would not think it would be conscionable to bring a case just because it's a similar sound and the notes are different. You can't copyright a sound, in my opinion. This is Dr. Katie Leo, who's a professor at Millikan University, who did her PhD thesis where she talks about the mellocentric approach in music copyright. And so this is a quote from the brief that was filed in support of Katy Perry. It says, the most important elements of a musical composition are melody, harmony, and rhythm. It's typically the most distinctive and memorable musical aspect of a popular song and musical works in general, because melody is what listeners readily comprehend, recall, and replicate. So what would you recall and replicate from the rap sections that we just listened to? da, 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 da. That is the most memorable part. So I think that something that bothers me a little bit is the idea that an ostinato in general is too secondary to ever be important enough to be protectable expression. I don't really take a position on whether there's not other prior art out there that would disqualify this for being protectable, but I don't think we can wholesale say that an ostinato is not protectable. I mean, to me, I know this is the most memorable part of the song because last night I couldn't sleep all night. I just kept hearing da 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 da, and I wanted to shoot myself. So it's one of those earworms. And so I'm probably out of time, right? But I'll just make one quick point. This is so common in contemporary pop music, this sort of minimalism now, where you have nothing more than a rap, a drum beat, and some ambient sounds, and an ostinato. And there are songs, I could give you some examples, where there's no harmony, there's no melody anywhere that could be transcribed like what we just looked at. There's not even a bass part in some of these songs. So but my question is, when you're dealing with this kind of minimalism, doesn't that also elevate some of this musical content in importance? And I throw that question out there, and I'm eager to hear what people think about that.
Great. Okay, Sandy, how do you think about these issues?
Oh,
Oh,
Because that thing's sitting up there like that, and it implies that I wrote those words. That was a quote in the brief from Fishman in Music is
you can't trust him.
I didn't attribute it to anyone. I didn't know who wrote it.
I thought it looked familiar, but yeah. Well, so how do you think about similarities, Sandy?
I think you have to take the musical work as a whole, and then you have to really focus in on the similar areas. And many times they're melody, many times they're a combination of melody and lyric. If two songs have the same melody and the same and similar lyric phrases, that's more problematic. But you see, pop songs are a lot of melody and lyrics and a lot of chords. You can't copyright chords in and of themselves or rhythm tracks in and of themselves, but in combination, they can have more meaning. But I would say that as rhythm has become much more important from the Afro-American point of view, and rap has become so important, that a rap, and we just settled a case with that, with the same phrase used and the same intonation and the same place in the measure.
Was
So
it the same lyrics, too?
it was the same lyrics. And there were so many similarities to this that it was very difficult to say that this was independently created. And on the other side, they had a lot of prior art examples,
Leave this slide
like
up.
about 35. But I'm sorry, I don't want to keep going.
Hey, just take the slide down.
Okay.
Yeah, I didn't want to leave that up there.
But none of these 35 examples.
Oh, no. It won't go away.
I'm my own form of earworm.
Oh! I'm sorry, I'm interrupting things.
Life finds a way. Anna, did you have slides as well that you wanted to?
I have slides.
Okay, yeah, you can put. Oh yeah.
Sorry.
Okay. Shall I go?
Sure, go ahead. Yeah.
Okay. Let's see if we have my slides up. Let me see if this is it. Yes. Okay, so now I have to be able to play it. I'm going to need some IT help, I think, on this. Can we put this into play mode?
This is, you opened the PDF.
Oh, I did. Okay, sorry. Where is it? Here it is. Okay. Sorry, all. And the pointer is. Okay. How do I? This isn't working, and I don't have a pointer. Or you know what? Let me use my own pointer. Sorry, guys. Oh boy, this is going to be tough.
I think there's.
Thank you. Okay, let's see if this works. Turn it on. Yeah. I'm trying to use this so it change the slides. Yeah, you have to put in that thing, yeah. Okay. Okay, all right. Okay. I tried to answer the questions that were brought up by Professor Fishman. Is your forensic practice getting busier, or is it business as usual? It was much, much busier. I do about 300 to 400 jobs a year. Most of them are preventative. In many cases, they were advertising agencies and film companies. Now what's happening is that the record companies and artists are having this problem. And so you can see, the job of a forensic musicologist is to be able to accurately find and transcribe in any form or notation or graphics the similar musical and important non-musical facts in the work and be able to show, explain, and demonstrate what those musical facts are to an average non-musical listener. So in a sense, I'm teaching people how to hear it. And I'll show you some slides that try to show that. I'm going to, looking at a piece and determining what is important, is it original, is it substantially similar, is it strikingly similar? There's always a question of prior art, which means things that come before the two pieces that you're analyzing. And always the question that comes to me philosophically is, what is original, and can you own that so that nobody else can ever use it? There are different genres of music, and there are common elements in those genres. Certainly country music tends to be more lyric-driven. Folk tends to be more lyric-driven. Blues is much more of a performance kind of thing. So each type of music you have to look at separately and see what is important and what are those things that are the same. And sample analysis, by the way, which I do a lot of, is a very different animal. You literally decompose and recompose the sample to see if, in fact, it really came from the original source. But I'm going to move quickly. This is a wonderful site for all of you, if you don't know this already. It's the Music Copyright Infringement Resource. And I put together the last 20 years. And I think you can see very clearly that in 2000, now, this doesn't mean all the cases that were ever done. These are what they have put on this site. But you can certainly see that there's a lot more from 2016 on that have made music copyright incredibly difficult and confusing. Here are some of the cases that affect creation. The Beach Boys, I'm going to run through this quickly. First major plagiarism case. George Harrison was the first unconscious plagiarism. The John Fogerty was the first case of accusation of copying yourself. It also was, it really also established that if the other side has no basis for having, in a nuisance claim or something like that, then attorney's fees can be rewarded to the prevailing party. The Vanilla Ice is a hysterical example of sample, and I don't know if any of you have seen it, but if you haven't, you have to try it. It's hysterical. De La Soul, what happened is that as samples became used more and more, people were basically put on alert because it costs a lot more to license a sample, and not only that, but damage. So interpolations, which are sound like the sample but are not, are created, have been used more and more. I would say that that is changing as well now because interpolations are sometimes, they're sometimes going over that too. Two Live Crew is an important case because it was fair use and parody could be used as a defense even on a commercially released recording. Fair use, interestingly enough, after the case was decided, they did settle, and Two Live Crew did license the piece from the publisher. Led Zeppelin, there is a question, there's an effort to apply the 1976 Copyright Act to the song, which falls into the 909 Act. I don't know how that's going to go. The next one is Uptown Funk, and there have been so many claims, and so many of them that actually I didn't think were merited much, but there has been a lot more cases brought, and it's easier to settle those cases than have to go into litigation. Economics really plays an important role. If you don't have a really hit song, you're not going to get sued. But if you do have a hit song, you very much likely could. This is an example of some of the new creative songwriting ideas where they have a track that you listen to this and tell me what you think are the same. The track. The person who did both of those tracks was the same person, and there are producers producing beats and tracks. They're slightly different and I'll show you where. If you look at the chords, the second chord is different, but you certainly do have the most common. Let's just listen to this, and let me use the pointer here. The other one, I can't point, unfortunately, I don't know how to do it. Both of these have extremely different melodies, although the chords and the tracks are very similar. And the one that was created for Already Gone is one of the most popularly used chord patterns in hit records. And if any of you want to look for axis of awesome, you know who I'm talking about? It's, okay. The 4-chord progression that every single hit seems to have. Okay, this is another example of the kind of songwriting that's happening. How many of you know Old Town Road? Okay, so you all know the story of Old Town Road too. Well, this obviously was a track that was bought online for $30. I'm just going to play a little bit of it. It uses an 808 drum sound, which is very characteristic of trap hip-hop pattern. It also contains a sample from Nine Inch Nails with limited distribution. But after it hit, they negotiated a much more appropriate. Okay. Again, another question I tried to answer. Do all of these recent judgments seem like, a natural extension of everything you've done? Well, no. There's a lot of confusion. There's significantly more artists, songwriters, and producers wanting to make a claim against a hit song. At the same time, more labels, artists, songwriters, and producers are increasingly moving toward prevention or insurance, because these things are coming out of the woodworks. Jury trials are exceedingly unpredictable, and the results can be serious and sometimes unintended. Music copyright infringement cases are complex, and one of my recommendations, and I've actually done this, when there was a case several years ago, the judge in California basically said, I cannot understand what these two experts are talking about, and I need somebody, and you two have to decide who that is. And I was selected. And it took about 2 months for me to research this before I could come up with an opinion, which neither side was happy with, but at least it was what I felt was the case. In all of my preventative work, if the work points specifically to any artist, musical work, or group, or if you use a reference track or are asked for a quote to license a musical work or were denied a sample use, you really could have a problem. And so for me to be able to, quote, clear those pieces of music, I highlight where the problems are, and then they have to change them before I'm going to clear it. Do we have time?
We're about ready for the Q&A portion.
Okay. Ooh, okay. Then I will not do this.
All right, so I have a ton of questions, but I know that probably people in the audience do too. So I'm going to pass the baton out this way. And particularly if any students have questions, I would love to begin there. Okay, I see one hand up. Yep, go ahead.
Do you guys think that juries made up of non-musicians are competent enough to? Yeah. Okay. So in cases that hinge on highly technical musical analysis, as musicians, do you guys think that juries made up of non-musicians are competent enough to decide whether there's infringement?
I'll be happy to answer.
Well,
I actually do not think so. I think it's very difficult, particularly if a jury is not familiar with a genre. You have a very short amount of time to teach them how to hear, and you put the graphs up. But the fact is, my feeling is that the first time they hear the pieces is when they form an opinion, and then there are other non-musical issues that come up, like in Blurred Line case. Robin Thicke was not a sympathetic character. In that case, there weren't two consecutive notes that were the same. But the jury made a decision, I think, based on non-musical facts that had a lot to do with Robin Thicke.
I agree. I think that is often, these intangible things that can come in play in a case. But I would disagree with you about whether juries are qualified to make these decisions. I think my job as a musicologist is not only to present the technical side of it, but to be able to put it into layperson's terms. So I think part of what we do is, in sort of an adversarial role, is try to make our cases to the jury and see, the jury will decide which expert they think is the most convincing. And you know, I teach a lot of music courses to undergraduates who have no musical training. So I kind of feel like I've gotten a lot of experience talking to people who are not musicians about music. And I think that's an important skill that you need to have if you're going to do this kind of work too.
I'd like to defer my answer to Cristalia because I read a paper that you wrote where you had answered this question.
Hi. Sorry, I was saying I don't know if I have an answer, but I will mention some proposals that might get talked about in the next panel. To the extent that juries find this difficult and complicated, well, one thing you might say is juries find lots of things difficult and complicated, and we still send those things to juries, right? So, you know, if we can send murders, perhaps we can send these. That said, you know, proposals have been, you know, should we have mandatory arbitration where it's being arbitrated by panels of musicians? There are problems with that as well. Could this something that could be handled in small claims court? Well, plaintiffs don't want that, right, because they're not looking to cap their damages. Could we have independent, neutral, court-appointed experts, as Sandy was mentioning? Maybe that's an answer. So there are other possibilities if we feel like this is particularly ill-suited to juries, but you know, noting we also send pretty highly complicated patent cases to juries too. So to the extent juries aren't doing a great job, it's not just a copyright problem.
So this is directly related to the similarities between the Kelly Clarkson and the Beyonce song. So a friend of mine runs a place called the Producer Dojo in Los Angeles. And I want to draw a bit of an analogy, which is to say the decreasing costs of production these days are in one sense very democratizing for musicians. Many people can actually have a studio on their laptop at a very low cost compared to what previously was the case. That being said, there's high levels of convergence towards certain dominant platforms or software suites for music production. And there's huge demand for sound packs and sample packs. My friend actually makes a considerable amount of money making those sample packs for Ableton. And so in one sense, there are more chefs potentially in the kitchen. But in the other sense, the set of ingredients that go into recipes and the set of ways that those recipes can be created are actually converging to a lower number. So my question is, do you think that actually there's more likelihood of infringement if all of these budding bedroom producers are drawing from the same sample and sound packs on the same audio platforms, and they're not engaged in the direct production of sound itself, but compiling those ingredients together in likely to be increasingly similar combinations?
I couldn't agree with you more. I mean, basically, there's a proliferation of sample libraries, track libraries, one of them I mentioned, but there are scores of them, score. There are lots of them. And I'm asked to comment on some of these many times because these third-party companies are getting these things from other people, and they're not really guaranteeing anything. So I think, and certainly I've found several of them that were too close to hit songs that were problematic. So I agree with you that everybody wants to write a hit idea and use the same kind of things is problematic. In the case, the case that I showed you, melodies and lyrics were so different, it didn't really matter. I felt that there was no problem with those.
Turning back to what you said earlier about overcoming an issue with the jury's unfamiliarity with a particular type of genre of music, is it advisable, in your opinion, to perhaps play a series of sample tracks that aren't at issue in that genre temporarily familiarize the jury with the genre so that when they hear the two tracks, they don't just sound the same because of the fact that the jury's unfamiliar with the genre? Is that something that you would explore as in presenting something like that to a jury?
Well, remember, what we do is to teach people how to hear. And if that's something that could be used, that's fine. But many of the cases right now are songs that are in the 1909 Copyright Act, so they were recorded before 1978 when you had to have a deposit copy at the at the Copyright Office. So if it's a recording that comes after that, then absolutely the sounds that's a useful thing to do in a particular case. I mean, again, I'd have to see what the specifics were.
I would just say that I've been involved in a couple of trials involving hip-hop songs in Nashville, and the jury was, in both of those instances, was not really familiar. Most of the jury was not that familiar with the genre. This was in about 16 years ago. They'd probably be much more familiar now. But I don't think it was really an issue because we were really dissecting the music to the point where I think they were able to distinguish the musical expression that we were talking about, the experts on each side, and really focus on that.
We have time for one more question.
Hi, my name's Daniel Abad. I should say off the jump so that nobody thinks they're being ambushed. I work for a music publisher that represents a portion of the work, Thinking Out Loud, and I'm aware that there may be people up here who are working for the plaintiffs in that case. But I just wanted to ask generally to the musicologists what your thoughts are on the use of mashups as evidence, and if that's, dirty pool, a way to trick a jury, basically.
I'm going to give this to you, but we totally agree that mashups are bogus.
They're misleading. They
Yes.
are completely inappropriate, unprofessional, and they should be abolished.
People send me mashups. I say, I don't want to even hear these. Send me the original tracks separately.
The bottom line is you can change the pitch, you can change the tempo, superimpose lots of things, and it just means that harmonically they're either compatible or they're using the same chords. It means nothing else. And it's very misleading, and particularly for juries who really don't understand music. It's just not appropriate. I hope that answers your question.
We agree.
Well, congratulations. We've reached consensus, so I consider this a job well done. So please join me in thanking our panel.
actually good timing.
So
and I have been writing about copyright for almost 40 years, and it's only gotten more interesting over time. And music copyright is one of the places where it's gotten more interesting. We have a great panel, and we're going to hear first from Reagan Smith, who's the General Counsel and Associate Register of Copyrights with the U.S. Copyright Office. She's going to be talking with us about some issues that the office has been addressing in this space, particularly about registration deposit copies, like what is the musical work from the standpoint of how the office understands it, about what kinds of things are copyright protectable in music from the standpoint of the office, because they filed a brief in the Led Zeppelin case that I think was very interesting. And we'll hear a little bit about de minimis and about that tricky question about what's the difference between the sound recording and the musical work, and what things that are performative are within the scope of which copyright, and that's actually something that is bedeviling the courts. After that, we will hear from Ed Lee, who is a professor at Chicago-Kent Law School and the head of its Chicago-Kent program on intellectual property law. He's been writing lately about whether fair use should be given more attention in music copyright cases. Fair use defenses are actually pretty uncommon, or have been pretty uncommon, but maybe they should be more so. After that, Latif Matima will be our next contributor. He's from Howard University Law School and the Institute for Intellectual Property and Social Justice. And he's going to talk to us about what's ideas in works and who are these litigations really impacting, what communities are really worrying about that. And finally, Kevin Erickson, who's with the Future of Music Coalition, is going to talk about what all these debates that these lawyers are having, what kind of impact is that having on the way that musicians are thinking about what they can and can't do, and also who is being really impacted by some of these lawsuits. And so I think it's going to be a pretty wide-ranging conversation. So Reagan, would you please get us started?
Thank you. Let's see. Okay. Thank you, Professor Samuelson, and thank you for having me here today. As you mentioned, I would like to take my time to step back before we get to infringement and talk about a little of the legal and policy frameworks from the perspective of copyrightability and the formalities, requirements to register your copyright with the Copyright Office and how that might affect infringement analysis that we get to. So I have some basic slides to start with. The first one is just originality. To have a copyright, let's see if this works. Yes, okay. Obviously, you need to have an original creation. There needs to be a modicum of creative expression. And the Copyright Office evaluates the originality requirement daily by administering the registration system. Section 202.1 of our regulations codifies the office's approach that short phrases are not copyrightable, ideas are not copyrightable, works of common property are not copyrightable. There's a list of those things that are taken from the Supreme Court's Feist opinion, from Title 17, 102B, and other circuit cases. It's built up over many decades, and the office's views are generally well received and used in district courts, and have received deference many times in private litigation or administrative challenges for this. As far as music specifically, we have a practice guide called the Compendium that talks about how the office thinks about registering musical works and sound recordings. So in terms of applying the common material standard to musical works, it says some examples of common property include diatonic or chromatic scales, arpeggios, or chord symbols based on standard chord progression. So those are things the Copyright Office would not register, nor would we register a short phrase consisting of only a few musical notes. For sound recordings, similarly, the office says the same thing. Short sound recordings may lack a sufficient amount of authorship to be copyrightable, just as words and short textual phrases are not copyrightable. And I don't think we've been pressed very often to look at what that line is. We do have one one case from the Copyright Office Review Board, which is sort of like the last stop in administrative adjudication over the Intel spiral. It goes dun, 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 dun. And the Copyright Office looked at the sample, what came in, because we look at what is sent into the Copyright Office, and that's what we evaluate, and determined that the sound recording aspect of it was copyrightable, but not the musical work based on the deposit material. So we kind of looked at that, said there are some performative elements on the sound recording side. So as Professor Garcia explained really well, there's a difference between musical works and sound recordings in copyright law, and that distinction drives different rights, it drives different statutory licensing schemes, and so it matters. But an interesting thing from the office's perspective is that what is registered is often the same thing. It will come in under the same MP3 or other deposit, because under Section 408, a phonorecord, such as a recording of a musical work, can be now submitted as a deposit, and that is a very common way, if you have the requisite, ownership of both sides of it, that you may register the musical work and the sound recording at the same time. So when sending something to the Copyright Office, generally, Section 408 says that you need to provide the Copyright Office with a complete copy of what you are seeking to register the claim in, or a phonorecord. And there's some administrative flexibility to alleviate that requirement by accepting identifying material, but that is not currently exercised in anything involving sound recordings or musical works. And why is that? Why does it say phonorecord? Why is that word there? That comes out of the law because this wasn't always the case. So sound recordings were not federally copyrightable until 1972. And under the 1909 Act, the office's regulations said a phonograph record or other sound recording is not considered a copy of the composition's recording on it. And the office did not accept recordings to register the musical work side of it. And that came from kind of a long precedent in musical work copyright law, starting from the White-Smith-Apollo case in 1908. The Supreme Court said to be a copy, there must be a written or printed record of it in intelligible notation. In the 1909 Act, which updated the copyright law then, the legislative history says that these piano rolls and phonorecords, we cannot think that they are copies within the meaning of the Copyright Act, and so you have this concept of a phonorecord. Also under that act, under the 1909 Act, copyright was secured by publication of the work together with a notice of copyright. Publication did not include distribution of a phonorecord when you're talking about the musical work. For unpublished musical works, an author could obtain copyright by registering with the Copyright Office one complete copy of the work, but again, phonorecords were not considered copies, so the office didn't accept them. And the musical works captured in phonorecords were considered unpublished. So we required sheet music or another form of visible notation to register the claims to copyright. Looking at the changes necessary for the 1976 Copyright Act, the 1961 Registrar's Report recognized that this was limiting. And so there's a report saying that transcription into written notation required for deposit is difficult, it's expensive, it's perhaps privileging some forms of expression over other ways musicians are creating songs. And the Copyright Office said maybe this should be changed. And so it was under the 1976 Act. Now, under Section 408, phonorecords can qualify as recordings of deposits, of musical work deposits. So where does that leave us now? In 1978, all unpublished material became protected by copyright. This was a change when copyright subsisted upon fixation, and it becomes, in some extent, a registration issue. So something that was in a recording, not registered through a non-recording deposit with the Copyright Office, now has copyright protection, but may not be registered at the Copyright Office to overcome the requirement to get into courts. So I think there's two considerations for that. First is maybe, since this is the policy panel, going forward, it seems to have improved to be able to send a phonorecord if that is more easier for lots of different musicians. And secondly, you can look at the existing deposit copies. Maybe you're capturing what a musician is thinking is most important of the features. And if not, perhaps the remainder material could be registered to complete the piece, or sort of as a derivative work By sending in the deposit requirement now, there's sort of nothing stopping sending that in to register the claim. And this is just a quick slide about the We Shall Overcome case, because I think this is a case that illustrates the importance that registration can have in these types of cases. So the one in the middle is the lyrics to the 1948 registration with a copyright that says, "We will overcome, we will overcome, we will overcome someday." It was not renewed. And then there's a 1960 copyright registration, which was at issue in the case. That is, "We shall overcome, we shall overcome." And the court said substituting the word "shall" for "will" is contested and trivial. It did not, it's not sufficient to create a new derivative work authorship. And that was dispositive, I think, in the court finding that "We Shall Overcome" is in the public domain. But connecting this to infringement considerations, the government did file an amicus brief in Skidmore versus Led Zeppelin. And, you know, if you're wondering, was it fun to go into DOJ and say, I think there's a significant government interest in Stairway to Heaven? Yes, that was sort of fun. Where the government interest was in explaining this deposit requirement, what had happened under the 1909 Act, which was the relevant copyright law for the composition Taurus, and looking at what is coming into the Copyright Office, remember, being the complete copy of the work, as helping influence the infringement considerations. So the government's brief says that the deposit copy in this case should define the scope, and you know, perhaps if there's additional elements of the composition in a recording, that could be registered separately, but it's not before the court. And then looking at copyrightability, the office argues that the copied portion of the composition at issue is subject at most to a thin copyright, and that standard musical elements are not protected. And a thin copyright would be evaluated under a virtually identical consideration. And it talks about some of the examples that the office has in its compendium as far as short musical phrases and chords and arpeggios that typically we would not consider to be copyrightable itself. And I think some of these principles might be helpful in looking at some of the cases that have come through the courts. On the side of lyrics, you see perhaps a tendency a little more for courts to be dismissing these cases. The phrase "walk it, talk it," or the "shake it off" case, although that has been on appeal, were dismissed as not copyrightable. The phrase "party and bullshit" was dismissed as fair use, which I think is sort of interesting, but also the Copyright Office probably wouldn't register that phrase by itself. Versus when you're looking at musical elements, it gets a little bit more complicated, and that may be related to these performative aspects and understanding where the line between what the musical work being registered is versus the sound recording, and the courts sorting, you know, addressing some of that. And then just a last note to think about is whether there's a difference on the de minimis standard. So you have the Sixth Circuit holding that there's no de minimis standard for sampling on the sound recording side. And then you have the Ninth Circuit saying, no, there is. There's nothing special about the protection for sound recordings. It's just a limited protection, but that does not affect evaluation. So that's what I've got, and happy to continue the discussion. Thank you.
I think we wanted to go through this first, but I know she'll be happy to answer many questions.
Mm-hmm.
Alleging infringement by another musical work since the inception of the 1976 Act. And basically, in this study I found, by and large, fair use is not the Supreme Court. Here's this one. In the vast majority of cases, as shown in this chart, the defendants have prevailed in music copyright infringement lawsuits. Roughly 90% of the cases. That might be changing more recently. In addition, there are other grounds, as shown in this next chart, on which the defendants have prevailed, mainly on challenging the elements of substantial similarity, whether it is on the access prong or on the prong of misappropriation. So one reason maybe fair use has not been pursued in the past is that defendants have prevailed in the majority of cases on other grounds contesting substantial similarity. But even in the cases in which the defendants have lost, they typically have not pursued a fair use defense, as in the case of blurred lines, even though the defendants admitted to some potential barring of something, whether it's the groove or something else. So the main finding of the first study that I did was that fair use is not typically pursued in music infringement cases outside of a handful of cases involving parodies. So that led me to the next study where I teamed up with a co-author, Dr. Andrew Muschernia, where we ran an experiment to test if fair use would actually matter in music infringement cases. So we conducted an experiment, and here are the basic contours of this experiment. We tested over 500 subjects using Amazon Turk. We created a fact scenario, a very simplistic fact scenario involving two sets of cases. One based on the music in blurred lines, another set of cases based on the music from the Harrison case, My Sweet Lord and He's So Fine. Now, we were not retrying these cases, I should underscore. We were creating a hypothetical case based on the music involving instrumental versions of the respective songs in these cases. And then we ran 4 cases testing substantial similarity, not access, but the actual question of misappropriation, and testing also fair use. And the reason why we chose these 2 sets of cases or music is that we wanted to have music that potentially could be found to be infringing. So we know from the results in these cases they were. But we also wanted to have cases that arguably there was a fair use argument could be made. We classified the blurred lines case as a case of low similarity compared to the case involving George Harrison, My Sweet Lord, because there were fewer note-for-note either identical notes or similarities in sequence. And that's the reason why we chose the 2 sets of songs. I don't want to go through all the facts of the case, but it's a very simplified version. This is what the subjects would see online on Amazon Turk. They're given the opportunity to listen to the instrumental versions as long as they wish, and then they're given jury instructions. A very simplified version of the substantial similarity instruction. We base this on a composite of jury instructions given in cases, as well as a composite of pattern instructions from various circuits. And this instruction was similar to 2 other experiments involving substantial similarity that were used by other scholars. So we, sort of validating our instruction was within what others had used. The fair use instruction is a little bit more challenging to present because obviously you have to give the 4 fair use factors in Section 107 of the Copyright Act. We also included a quote from the Acuff-Rose case involving transformative use in Factor 1. But otherwise, this hews fairly closely to the statute. Okay. What are the findings of this experiment? Well, the first main finding is that fair use does matter. Now, maybe to the copyright students and professors in the room and lawyers as well, this does not seem like an earth-shattering finding. But let me just throw out one possible hypothesis why this is worth proving or validating with this study. Some might say, well, misappropriation and fair use, the fact finder might
end up with the same result, basically treating misappropriation as going too far or being unfair, as well as making the determination of fair use as something that's unfair, and in a post hoc rationalization, just doing the analysis under the respective tests. What our findings showed is that that's not what's going on in terms of these music experiments. Okay, so in this chart, you can see that in terms of the findings of no liability, depicted in orange would be the number of findings of no liability finding in favor of fair use, compared to the blue would be no liability by rejecting substantial similarity. So as you can see, the orange bar is greater than the blue bar, meaning that there were more findings of fair use than there were rejections of substantial similarity. So fair use does matter, basically. Relatedly, this is an interesting sort of sub-finding of this first finding, is that people were more confident in finding fair use than in rejecting fair use. So we asked the respondents, how confident on a scale of 1 to 10 are you in making your finding, whether it be substantial similarity or fair use? The only finding that the respondents showed a lower confidence, below 7, was when they rejected fair use, which suggests that if you present a fair use defense, the fact finder or the jurors here would be taking into, I think, consideration their worry about whether, before rejecting fair use, whether they were right. Okay. The second major finding of the experiment was that knowledge matters. And this relates to the gentleman's question before about the jurors' lack of knowledge or expertise in music. We found that people who had knowledge in music, or the law generally, being law students or lawyers, and then the question about musicians, either they studied music or actually were musicians, that actually had a significant effect on the findings. And it had an effect that maybe is surprising. The effect that we can characterize is somewhat of an inverse relationship. People with knowledge of music or the law were more likely to find substantial similarity or infringement, given the test of substantial similarity. By the same token, those people with such knowledge of music or the law were more likely to find fair use. And that's the inverse relationship. Now, why is this happening? And actually, the people who had knowledge of law, it was even a more pronounced effect in terms of knowledge making a difference in terms of their findings. Why might this be so? Well, we posit that what this knowledge effect is showing is that people with knowledge of music or the law have greater sensitivity or understanding of the differences in the legal rules for substantial similarity or fair use. And for the people who have knowledge of music, they have greater sensitivity to the similarities and differences in the musical works. So that's why you would see greater findings of substantial similarity. By the same token, greater findings of fair use, understanding the rule. So that's this inverse relationship. Now, we're planning on doing more experiments, testing the role of musicologists and experts and how they can educate respondents in terms of their understanding of the two musical works. So that's something on the horizon, and if you have further questions about it, here's my email address, and this is a work in progress, so we're happy to take your comments or suggestions on it.
Great.
That these cases are up the mic. Yeah, I don't know why it's not. I do IP. Oh. Shall I keep talking?
Uh-oh.
Sing because I might. That's it. Yep, that's it. Okay. See, don't blame me. I didn't do it. Okay, so
in looking at it, thinking about the impact that these cases and these analyses have on various constituents within both the musical community and just within our population as a whole, I got involved in this, in the Blurred Lines case, really just, I guess the legal description of it is that I just was ticked off because with the first decision in the Blurred Lines case, meaning when the jury's verdict came out, there was this incredible reaction from lots of, but in particular from the scholarly community. It was this incredible outrage. Am I doing something wrong? Okay, no, it's not me this time. There was this incredible outrage. How could this happen, right? It was as if, one, we always had a perfect system for assessing copyright infringement when it comes to music. And two, never before had this system ever resulted in a verdict that might be questionable, right? And I'm like, wait a second. These are the rules that we have always litigated these cases by. They're in certain segments, for certain communities. You can look at African Americans in the music industry, et cetera, there's a legion of decisions that people would question, and they would say, that doesn't quite seem to be a fair or correct result. And the answer would be, yeah, it's not a perfect system. These are the rules. These are the things that we look at, et cetera, et cetera. So there was never this incredible outrage before. It just struck me as if these are the rules. These are the rules. These are the rules until I lose, right? And that is what got me interested in this. The fact of the matter is that what I think the Blurred Lines case demonstrated, and full disclosure, because of that, myself and two other law professors, we wrote one of the two amicus briefs, because there were only two amicus briefs in support of the gay estate on appeal, right? And I like to say two was all that it was needed, because it came out the way we thought it ought to come out. I think what the Blurred Lines case, and this is one of the things that we argued in our brief, is that what the Blurred Lines decision demonstrate, it illuminated for everybody once and for all that, hey, look, this is not a perfect system, right? What we're doing is we're taking an infringement framework that was conceived for literary works, and we're trying to fit it onto music. And so right there you have an inapt fit. And then, even when we did that as far as music was concerned, at the time that we were doing it, we were thinking about a particular type of music. We were thinking at that time about classical music, which in and of itself is particularly amenable to some of the things that we do when we look for in copyright infringement. For example, it is particularly amenable to written notation, right? And so now we have it twice removed. We're taking something that was created for literary works that is kind of fitting for classical music, and now we're going to try to apply it to other musical formats that are very different from classical music. And, you know, it's like, at what point is the copy of a copy of a copy, is the resolution off? Like, why don't we just stand up and admit that, right? So rather than this great indignation as to the result that happened in Blurred Lines, why don't we use this as an opportunity to make some observations? First, this observation about the tests and the mechanisms that we are using, they are an inexact fit. But while we're on that, let's make some other observations and some other acknowledgments that in addition to the flaws that we see from this inexact fit, some of the other flaws in the system that we had been relying on, you know, for 200 years is that who wins, another dispositive factor, is whether or not you have appropriate resources. Now that includes money, but also do you have resources to hire a musicologist, right? Because if you're doing that first step of the infringement analysis, what's protectable here, right? And if one party says, and I have Dr. So-and-so here, and he says that this is so, da-da-da, and then you go to the other party and they say, and what do you have to say? And he says, yeah, well, I know my music is good. You kind of are at an imbalance, right, in that comparison. And then there's another resource question. For certain types of music formats, do we even have experts, right? right? Or are we importing people who are experts, and this is not a swipe at experts, right? Are we bringing in people who are really, truly experts in terms of certain music forms or music genres, which I don't like to use genre, but that's a whole other thing for me, and then asking them to assess something else, right? And so I think that what the case demonstrated is that, okay, yes, we have some problems here, right? One other problem was that as we are sitting down, let's assume that the fit is not too bad, and let's assume that the expert is a kind of as close as we can get. I also wondered whether or not this also revealed that sometimes some of the assessments that we were making are based upon some extrinsic factors, right? Like whether or not we want to admit it, the race of the litigants. And how that could be relevant, not just in terms of a resource question, is that there is some traditions in our culture of looking at, okay, what nice European classic composers, when they sit down with the quill pen and the music notes, what they do is creative, right? But what you other guys do, that's just emotion and percussion, okay? And that so maybe there are some assessments that are built into what we're doing, right? So if we can agree, or at least for me, I can certainly agree, that, okay, we have an imperfect system, then perhaps instead of being so outraged about the blurred lines, that what we should have done is we should have looked at this as an opportunity to assess what we're doing, to say that the system has some breaks, has some flaws, and why don't we use this as an opportunity to fix it, right? To at least try to fix it. To first and foremost try to come up with assessment mechanisms for music creativity and music copyright and music infringement that is acknowledge that we don't have a great fit and see if we can improve it, right? And then secondly, try to come up with mechanisms that will accommodate a wide range of musical forms and a wide range of musical creativity, right? Because the fact of the matter is that we happen to be blessed or cursed, whichever way you want to look at it, to be in a society in which pretty much almost every musical form is present, right? Because we're the most diverse country on the planet, right? So you don't really want to come up with a music copyright system that says this works really good for one music format and it's kind of crappy for other musical forms, but we could live with that. Why would we? We don't have to, right? So perhaps this is the opportunity to sit down and to look at it from that perspective and to try to reconstruct the system appropriately. I think one last thought that I would add in this shifting of our focus to recognize the limitations of what we're doing and the need to broaden it is to also keep in mind what is the ultimate objective here. The ultimate objective is not to promote one kind of creativity, it's to promote all kinds of musical creativity without regard to what type of musical format you are involved in. The other thing that we want to do is we really also want to get to, well, what's really important here? Yes, what's really important at a kind of a meta-structural level, but also what's important in terms of what happens to music out there in the real world in the actual marketplace. Because something that does strike me about some approaches of breaking it down into these musical components, et cetera, and then stopping there and then, putting up the two slides. I don't mean PowerPoint slides. I mean like two little microscope slides, like this was, in biology, is that I don't think, if we had two cakes, I bake a cake, you bake a cake, and you accuse me of stealing your recipe, I don't think we would take each cake, put it in a centrifuge, right? Distill the ingredients, and then compare the list and say, ooh, yes, cake, flour, sugar, cinnamon, so ergo they are the same. We would be missing the bloody point, right? At some point, in addition to that analysis, what we got to do is we've got to taste the thing, right? And the fact of the matter is that irrespective of what that centrifugal analysis shows us, we do also have to ask ourselves, when people listen to this, what do they hear? And one of the reasons for me why that is just so critical is an observation and an acknowledgement and a concession I have to make about myself. Years ago, after, I grew up in a particular part of the world, et cetera, and I was not familiar with classical music. So it must have been either my last year in high school or my first year in college, I decided to take a classical music course. And at one point in the course, we were supposed to understand the concept of movements, right? And I'm listening, and dutifully, I still have the 30 greatest classical records. I don't know what they're talking about. It was like a couple of years later, a music that I've always listened to since I was a teenager is jazz. And one night, this is years later, I'm not even thinking about this, I'm listening, and all of a sudden I said, what just happened in that jazz piece? Wait, it happened again. And all of a sudden I realized, holy, that's what they were talking about with movements, right? The sheer truth of it was that there is a certain cultural element, right? That maybe there are some times that I'm not just putting on earmuffs, that I'm not just refusing to acknowledge that this is something like that, right? It's just that I may have insufficient familiarity, right, to be able to detect it. And I know all of this makes all of this so terribly messy. It's sort of like, well, then what do we do? How do we craft a system that's going to give us certainty? But I think that that's, again, one of the curses of diversity. We've got multiple types of music. We have multiple types of talent. The fact that it's going to be harder to go back and sit down from scratch and say, how do we more appropriately apply copyright infringement and acknowledge we have various musical formats? Fine. I just think we need to roll up our sleeves and do that work. And whenever we can't do that work, let's be honest about the fact that, hey, in some instances the mechanism isn't working. It isn't identifying all aspects of creative contribution. And let's at least acknowledge that, as opposed to be condescending and to say to those musical genres for which the system doesn't work, just putting a derogatory label onto it and saying that, well, what you were doing wasn't creative anyway. That's it for me.
Kevin.
So let me first just say that when I'm talking about cases today, I'm speaking in my personal capacity. The organization I direct, Future Music Coalition, only very rarely takes positions on specific legal disputes. I'm speaking more as somebody who thinks a lot about copyright and tries to connect the concerns of communities that I'm part of. As a practitioner, I'm a record producer and musician for a couple hours a week. To what's happening in policy and to other kinds of diverse communities of creators. And so I'm not sure that I actually have the strongest opinions about these particular cases. I suspect that if I was on the juries, I'd likely have sided with Pharrell, although I agree with much of what you're saying about these resource questions. I would have likely have sided with Katy Perry. For me, the concerns about chilled expression are somewhat muted because of the lack of a legal precedent automatically from jury trials. Of course, we've got to watch those appeals for the potential things that might happen in the future. But zooming out, much of the public conversation about many of these music business topics involving music copyright center on the actions and the concerns of a relatively small subset of high-profile celebrities whose experience is perhaps not representative of the broader population. And so when outliers define narratives, I want to think about who's being left out. Jeff and Sandy both spoke to this a bit on the on the music panel earlier. To get embroiled in a case like this as a company or as an individual, you usually need to be either successful enough to be a target for an infringement suit. If you're not making money, nobody's probably going to bother. Or you need to be successful enough to be able to sue someone, to be able to afford counsel to bring an infringement suit. That is not cheap. Media tends to fixate on these kinds of on these parts of the puzzle because it involves celebrities who sometimes say funny or embarrassing things in deposition. It involves controversy. It involves large dollar amounts. Legal professionals tend to focus on these narrow subsets because they tend to be the kinds of people or companies who could afford to hire counsel. Please understand that's not a jab at the legal profession, but we appreciate lawyers who take on cases on a pro bono or contingency basis, but it's just sort of the practical reality. Academics may focus on these subsets because to the extent that there's legal cases to write about, that's most of what there is to write about. Research that captures broader populations of working creators at the ground level and where you you spend time actually talking to them and checking against selection bias. That's really hard and time consuming and really hard to fund. Academics who are trying to do that, thank you, I see you. But you see, by the time we get to a policy conversation at the federal level, well, what can policymakers really rely on to guide their understanding of these issues beyond what they're getting through media, through legal discourse, through the academic conversation? And then you have a policy environment where creator groups and small business groups are just so much less muscle than either the big industry players, sure, but also that even is dwarfed by private equity companies and especially large technology firms that have a particular point of view on some of these issues. So I like to think through a situation where a good friend, a mid-career working musician who had a lyric lifted and reused in a song by a multi-platinum artist. This was not subtle, it was the chorus hook. I can't give you specifics, but there would be a potential for a strong, substantial similarity case, and that case will never be heard by a judge or jury because they cannot afford to bring a suit. They don't have access to remedies. I hear stories like this with some frequency. Another friend who found one of their songs was being used in an obvious re-record for an advertisement, no real recourse. It's because they lack wealth and the justice system is not organized around their needs. So for a person like that, a case like Dark Horse may be sort of interesting in the way that watching The Masked Singer is interesting, but it has about as much to do with their day-to-day reality. What would it mean to center the policy conversation on workers like that, on the majority of working creators who are not operating at that mass market scale? I think the CASE Act, which is a piece of legislation that creates an accessible and balanced small claims process, would it be at least be a partial solution, at least to get parties to the table to negotiate an appropriate settlement when that's a possibility. I don't want to turn this into a CASE Act debate. That would be a whole other conference. But as a fundamental policy issue, I want to just emphasize that the access to remedies piece matters a whole lot. And then more alarming to me than the cases themselves is the potential impact on the public discourse and the way that these kinds of celebrity cases can get weaponized in other policy issues and in public discourse. Sometimes by creating kind of a moral panic or sometimes reducing it to something really unimaginative, like, clearly copyright is out of control, and it reinforces this narrative of more copyright versus less copyright, this idea that creators and copyright owners just want copyright to get bigger, and the public interest would be better off if copyright got smaller. And this framing always obscures as much as it reveals, more than it reveals, actually. We need better copyright policy that effectively and equitably rewards creators, enriches communities, serves the public interest, encourages industries to be built on sustainable cultural production rather than extraction of value. Another sort of variant narrative that I worry about is, oh, isn't this funny? Now the big bad companies who argued for an expansionist view of copyright are getting screwed over by this, which is just wrong on multiple levels. It conflates a point of view on unrelated copyright definitional issues like term with questions about what the threshold for similarity should be. But also the large companies are gonna be fine. Certainly they'd prefer not to have to deal with this stuff, to be adjudicating these things, but they're gonna be fine. More at risk are songwriters and composers, particularly professional songwriters working in these large-scale markets. That population is facing a new kind of precarity resulting in part from format shifts and changes in revenue apportionment. Our research found that professional songwriters who don't record as performing artists themselves, but are just songwriters, are likely to be the most dependent on copyright-related income. These people never sued anybody's grandma over MP3s. They are not responsible for the Supreme Court decision over term length. And so there's the potential that this story, copyright is out of control, calcifies into these writers are greedy, get a real job, which turns into everything's fine. We don't have to listen to these people's concerns about their Spotify rates. Right, so when we allow ourselves to reduce complexity, it can be a really costly error. It can come at the expense of accurate understanding, but also at the expense of empathy and curiosity. I would like to hope that looking seriously at substantial similarity cases could lead us the opposite direction to say, yeah, creativity is really complicated. There are elements that are original, there are elements that are imitative, and there are elements that are iterative. We we can come up with a series of mental shortcuts and analogs to try and reduce the messiness of how creation works and try and shear off some of the complexity and box it into a story that aligns with our preferred view of the world. You know, policy questions about what we collectively owe to creators and what creators owe to each other, they have legal dimensions, yes, but they also have ethical and moral dimensions that are happening against a backdrop of complicated power relationships. So in an environment of polarization of the discourse, there's not a lot of room to investigate whether that understanding of power relations is accurate and complete and up to date. So I guess what I would say is just let's use these cases as an opportunity to engage with complexity and deepen our understanding of complexity and look at ways that policy can accommodate complexity.
Okay. So, like Joe, I could ask questions, but I know that the students in particular are interested in having some opportunity to engage with our speakers. So do we have a student who wants to offer the first question or comment? There's one.
Before the influx of copyright infringement cases in the past couple of decades, a lot of genres in the past, like doo-wop in the 50s and 60s or electronic dance music in the 90s, developed by artists borrowing grooves or combinations of musical elements from one another. Do you think the recent jury verdicts will ultimately prevent new genres from forming because artists are precluded from borrowing combinations of elements that could potentially define a new style?
My immediate reaction is no. I have two responses. One is, I think artists will be more reluctant to admit musical borrowing, which is something that is pervasive, and it goes back to Bach, and musicologists have been studying the practice of musical borrowing, but that admission now, I think, is verboten. It's an invitation to a lawsuit. The reason why I don't think that we're going to see the end of new genres or a new kind of music is that, at least from what I've studied in terms of how popular music is being created today, everybody is trying to create something that is somewhat new, but has some familiarity. There have been studies that have shown humans respond emotionally to music that they're more familiar with, and that gets them back to listen to it again. So I think what producers are trying to do now, and this has been going on for some time, is that they're using kind of a formulaic approach where it's something familiar, but they're trying to do something new. Like Billie Eilish would be a great example. Like people think like her style of music is, different or unique, and people know that she and her brother created their music on an Apple computer in their bedroom. So I think, and somebody referenced this before, democratization of music production. So I think we won't see the end of creativity and the end of new styles of music, et cetera, whatever. But there is this convergence, as referenced before, that there's a formulaic kind of approach to popular music that creates these similarities.
I would agree with Ed's conclusion, because I think that one of the reasons that there is this sort of like sky is falling fear that the new result is going to be that people aren't going to borrow and exchange anymore is because of the creation of this false narrative that what some of us are saying is that influence, homage, borrowing, all of that is bad. And that's not what at least I'm saying, okay? What I think on the earlier panel, one of the other panelists, she was explaining that, hey, as an artist, we try to be original, right? If we discover that we have inadvertently copied something, she wasn't saying that, we're like, no, we don't want to do that because I'm afraid of copyright infringement. I mean, that came later, right? But before these cases, artists were like, well, no, I don't copy. Like, I want to be my own person, right? I think what the issue here is this. It is a spectrum, right? You have, inspiration, influence, homage, borrowing, copying, theft, right? And the problem is that it's a sliding spectrum, right? And what we're trying to do is we're trying to figure out, and what I think artists try to do, no artist, no legitimate artist wants to be here, right? All legitimate artists, first off, they want to be not even on the spectrum. They want to. It came from my head like Zeus, right? But to whatever extent other stuff has an impact, I'm here in this space. And all it is that we're trying to do is to say, let's try to see if we can figure out where the line is going to be, right? And if we can figure out where the line is going to be, all of this stuff here should still happen. All of that stuff is good. That's promoting creativity. All of the stuff that's on this side of the line is bad. Let's acknowledge that it's difficult to find where the line goes. Let's also acknowledge that it's difficult to determine that one line fits every musical spectrum. It may be that, where you place the spectrum in classical music, where you place the line, might be different in terms of where you place it in jazz improvisational music.
Yeah, and I would come to the same conclusion. I'm not really worried about the loss of that interplay or new forms developing. I think that different kinds of communities have different sort of practices about acknowledgement of influence, and I think that there is some kinds of context where people really prize innovation, and this has never been done before. And there are other contexts where wearing your influences on your sleeves and actually just kind of having the coolest influences is something that people try to highlight and talk about in media interviews and stuff. And they're still working towards the goal of doing something that's uniquely theirs, but have no problem. In part because they're not making any money and not at any risk of a lawsuit, but have no problem talking openly about, this was influenced by that one record.
So I think actually one thing that Reagan talked about was this notion that some copyright in music are thin and some of them are thick. And that's actually a concept that you see in a number of other parts of copyright law. So in music, the thick ones are the ones that are highly original. Gee, I never heard anything like this before. It really was highly creative and kind of stayed away from other things. And then there are things that are kind of pretty common for works of this kind. And so the pretty common for works of this kind, or short parts of those kinds of works, tend to have a thinner copyright, which means that it's more likely that you have to have exact or near exact copying in order to infringe. The thicker ones, you're more willing to sort of say, well, there's too much of what's appealing to the audience about it, so that even if there's this difference and that difference, there is actually this notion that there are different scopes for musical works. And I think that's actually something that we've come to have sort of to articulate more lately than in the past cases for a decade or more before that. So just to kind of supplement, I think it relates to your point, because to the extent that there were little doo-wops, right? The doo-wop part is actually savoir-faire, or what the kind of common elements of works of that kind, and so less likely to attract some infringement suits. So we've had at least one question from a student. Any others? I know you had a question or a comment you wanted to make, Alex.
This is for Ms. Smith. I've seen it,
Here comes a microphone.
Oh, thank you. This proposed remedy for elements of a composition that were not protected by the original deposit copy because they weren't included in it, and you put up the deposit copy of Taurus. And you said there was a remedy where you could deposit a new version of the work as a derivative work that would comprise those elements that were not included in the original. My question is, several lawyers have told me that the problem with that is that the subsequent registration will only cover those elements that were not in the original. So in other words, say in Taurus, in the first 4 measures, it's missing 20 notes, but they're kind of randomly spaced in the deposit copy. Is it true then that you really can't combine the 2 different deposit copies in a lawsuit because they would be considered 2 different works? So it seems like that maybe is not really a remedy after all, or are these lawyers misunderstanding that?
Someone
Yeah, but
behind
then
you
it-
just
you would
said
have
sue
to
for
prove-
infringement of both works. You didn't have a mic, so.
Sorry?
Someone behind you just said, why don't you sue for infringement of both
Because
works?
I don't think you can file a lawsuit where you combine 2 different works and say, I mean, it would be considered whether it infringes on one and then infringes on the other. I don't think you can say that it infringed on the 2 collectively because they're considered 2 separate works. That's what I've been told.
So I think that the Copyright Office view, it's not like this is a policy panel, it's not like a policy take, it's just a legal take as to what could come in and be registered. So it was the case that we could only register fixed notation. And then this left things that were unpublished that all of a sudden copyright subsisted in, right? And then we would register it. And so it's also the case that the office, you're not supposed to register 2 copyrights of the same thing, which is going to your point why you would sort of subtract one and have 2 pieces. So derivative may not necessarily be the right phrase for it, but two components of something. And I think that what a court would do is really a question for a court. But I think that whether that is a helpful consideration. I definitely think it's a helpful consideration. I think there's many cases where different versions of works already are registered with the Copyright Office, and courts do manage to sort that out. And it's also I'm not saying we couldn't sit here and spin out interesting hypotheticals, and whether Taurus is one of those interesting hypotheticals or not, I'm not, really opining about. But if what is originally sent to the Copyright Office, and in that case it was 4 bars, which are what they are and are described in lots of the briefs. If that's supposed to be the kind of heart of the work, then you could maybe look at that. And if it's these other 20 notes that weren't on there for whatever reason, some of them, honestly very good in terms of people not having this training that is maybe more tilted towards classical notation, you could also register that and see, and that would kind of be up to a court how to evaluate it.
So we have 1 minute left. Blake, did you want to ask a question?
So just wondering about, we've talked today about basically the governance of songwriting, right? What are the rules that govern how people write works? And we've heard of evaluations getting made by songwriters themselves, by basically folks at the record labels doing risk analysis before putting it out. We've heard about the Copyright Office doing some of the work on registration. We have juries doing some of it. We have courts, both trial and appellate, doing some of it. My question is, where is the best institutional home, or maybe what's the right mix of institutional homes for evaluating these questions? Is how we have it allocated now the right mix, or if you could change it somehow, what would that be?
Oh, that's a 1 minute question for sure.
Well, I think think that it's hard to know exactly where the baseline is because you do have these different bodies talking about things. This will just kill the 1 minute, but one of the cases that didn't come up that I thought was really interesting was the pound cake case for Drake. And that is interesting because the sound recording was licensed and the musical work was not, and they won on fair use. But when you actually kind of get into why is it fair use, some of it is kind of based on how it might be used in hip hop specifically. But one of the lyrics is like about the A&R man. And if you don't like the A&R man telling you how to make your sound, I think one article that was interesting that got a lot of like chatter in DC is like the insurance company telling you how to write your song, and that might be a sign. If that's really, really what's going on, that might be a little too far. So.
And with that, please join me in thanking our panelists.
I think we have another 15-minute break and then a final panel, which will be dynamite.
We're having audio problems, I think. I can hear you fine. I don't think. Okay. I love to Colorado. I can hear you. Can you hear me? Oh, now I can't hear you at all. The sound just went dead. Nope. Now I can. Now I yes. And you can hear me. Hello, how's everything going there? Is it going well? I hope it's going well. Maybe not. Testing 1, 2, 3. Just making sure the microphone's working, making sure the audio is working. I'm gonna keep talking so we can make sure that we get the audio.
All right. So is the audio on?
I can hear you now.
Okay.
Video has done something pretty strange, so I'm not sure what's happening on your end. Can you hear me? Okay?
You can't see me, right?
I cannot see you. I can see the front of the room.
How long till we go live?
We got about 10 minutes, 8 minutes.
Okay. Give me 1 second.
Okay.
Should I just use the audio on my computer, or should I put headphones on?
Are you asking me that question?
I don't know.
I mean, I can hear you fine. If you can hear me fine, then I don't know.
All right. Let me give me a minute, okay?
Okay.
Let me figure out this audio thing. I mean this video thing. Okay, hold on a second. I'm gonna mute it for a second.
Yep. When you're speaking, it'll be taken from this. And otherwise, we're up on a television
Right.
in the front of the room next to the tape.
Got it. Yeah, I can hear you.
Yep.
So we make funny faces. The kids can see it right now, or no?
I think they can see it. I think we're on split screen in the front of the room.
You can see me. You can hear me. Can we wave? This is wild. Okay. I like the kid in the front there with the suit. I wore my suit today as well.
I'm going to give a brief, oh, it does work better when I turn my head. I'm going to give a brief introduction of our panelists, and then I'm going to let them give some thoughts, each of them individually. We'll turn to discussion amongst ourselves, and then as the other panels have done, we'll try to save some time at the end to bring you guys into our discussion before we break for our reception. First, we will hear from Professor Lydia Loren, who teaches intellectual property courses at Lewis and Clark Law School. She is also the co-author of a casebook on intellectual property and copyright in particular. She has been elected to the AOI for the restatement of copyright. And she is the author of one of my favorite articles, Fair Use and Affirmative Defense, which some of you may know as being cited in the Lens case, where we finally got confirmation of fair use as a excuse to infringement and not as an affirmative defense. So she's very famous for that. We will then hear from Francis Malafie, who's joining us also on the screen here. Thank you, Francis, for being here.
Sure. I'm sorry I'm not there in person.
Yes, we're sorry not to have you here. Francis is perhaps best known at the moment for being the lawyer who is suing Led Zeppelin on behalf of Randy Wolf, California's estate. Led Zeppelin is nonetheless a group that he calls still his favorite band. So he can talk to us a little bit about that. He was also behind a $44 million verdict against Usher and the writers of Bad Girl in 2018. So he will give us some thoughts on where substantial similarity cases are and what he's noticed as being an important focus of them. Kenneth Freundlich will then speak with us. Kenneth has been working in music and for artists for over 30 years in various capacities, as a lawyer, as a producer, as the owner of a digital record label. He's also counsel of record for some of the most important and influential amicus briefs that have been filed in this area, including recently an amicus brief filed on behalf of musicologists in the Dark Horse case that we were discussing earlier in this conference. Then we will close out with Richard Bush, who many of you know, and my copyright students need no introduction. He is the representative for the Gay estate in the Blurred Lines litigation. Before that, he has done lots of work for Bridgeport, such as in Bridgeport versus Dimension Films, Bridgeport versus UMG, most recently in that arena, the VMG Sal Sol versus Chacon case. And we are especially grateful to have him here, as he has been very busy lately securing an unprecedented temporary restraining order on behalf of Megan Thee Stallion. I don't know if anyone's been following this case, but this TRO allows her music to be released tomorrow, where her record label was otherwise not going to allow that to take place. So I believe he argued an emergency just now, and now he's here to join us. So Without further ado, I'll turn it over to Lydia. She's going to discuss some procedural points, including burdens of proof, and then we'll move on to Francis, Kenneth, and Richard, and then have some rebuttals and discussion amongst ourselves. Take it away, Lydia.
All right. Well, thank you very much. I really want to thank Christelia for organizing such a great gathering, and I want to thank all of the participants for their thoughtful and thought-provoking remarks. And also, I really want a big shout out to the IT staff at UC Boulder for making it possible for me to participate remotely. Is the sound coming through okay? Everything good?
Yes.
Perfect.
Fabulous. Okay. Well, so I've been following the Twitter feed for the conference, and I want to flag something that Professor Blake Reed said. He said, watching people argue about different theories of substantial similarity is like watching athletes playing different sports against each other on the same field. So this is the legal panel. And so what I wanted to do was focus my remarks on the very important part of the structure of civil lawsuits. And that is the burden of proof within the structure of the copyright infringement lawsuit. And by doing that, I hope to get us all at least playing the same sport. So there are some PowerPoint slides. They're available on the conference website, but I can't both be there remotely and show you the slides. So so you can pull the slides if you want to follow along with the slides. But we all know that in a civil lawsuit, it's the plaintiff's burden to prove a claim of infringement. And what exactly the plaintiff must demonstrate to successfully carry that burden is actually not expressly laid out in the Copyright Act. So instead, we look to the Supreme Court for the modern articulation of the prima facie case of infringement. According to the court in Feist, a plaintiff must demonstrate two elements, which the court helpfully numbers for us. One, ownership of a valid copyright, and two, copying of constituent elements of the work that are original. But unfortunately, that numbering is misleading, right? Each of those two elements actually has two parts to it. So the first element is both ownership and validity. And then the second element is both copying, right? That the defendant copied from the valid copyrighted work owned by the plaintiff, and also that the copying was improper, that it was copying of elements of that copyrighted work that are original, and enough of them that we would call it substantially similar. So we go from 2 elements to 4 elements, and it's in proving that final element, the final number 4, and the final 2 elements, number 3 and number 4, where the similarities in the 2 works, which is the focus of the conference, are relevant. So in 2018, the Ninth Circuit issued a decision in a case involving 2 photos of Michael Jordan, the Rentmeister decision. So it's Rentmeister versus Nike. And the Ninth Circuit helpfully labels those 2 final elements as copying and unlawful appropriation. And I'm going to try to use those labels for clarity. So before examining the role of substantial similarity in more detail, let me return to the concept of burden of proof. So we say that an infringement plaintiff bears the burden of proof on a prima facie case of infringement. And what that really means is that the plaintiff bears the burden of persuasion. Convince the jury that the elements have been shown by a preponderance of the evidence. But then there's also a subsidiary burden that we sometimes refer to as the burden of production, right? And that burden might shift between the plaintiff and the defendant, but always the ultimate burden of proof, the burden of persuading the jury on that prima facie case, remains on the plaintiff. So if the plaintiff has presented sufficient evidence from which a jury could reasonably conclude that the element is met, then the defendant is going to want to raise defenses. Now, some of those defenses are meant to actually chip away at the prima facie case. They're meant to, cast doubt on the story that the plaintiff is telling, make it so that the jury will decide that they are not convinced that the plaintiff has carried its burden. And these types of defenses, I think, it's really important to understand, those are not affirmative defenses. They are instead more accurately characterized as rebuttals. They're rebuttals to the plaintiff's prima facie case. And those rebuttals, they can be factual or they can be legal rebuttals. So the defendant might be introducing some new factual evidence that helps rebut access, for example, or they might be saying legal arguments as to why a particular aspect of the work is uncopyrightable. So this structure of the prima facie case and the role of defense rebuttals, I think, is critically important for a court to correctly apply the tests of substantial similarity. And that's because, right, substantial similarity is used by the plaintiff to prove both the third and the fourth elements of the prima facie case of infringement. And those 2 separate elements, the plaintiff has to prove both of them, right? The plaintiff has to prove the defendant copied from the plaintiff's copyrighted work, the copying prong, and also the plaintiff has to prove that the copying was of enough of the original elements that the copying is improper, what the Ninth Circuit terms the unlawful appropriation element. So take the first of those, that the defendant copied from the plaintiff's copyrighted work. So sometimes we'll have direct evidence. We might have session tapes where we have the defendant saying, hey, let's use that bass riff from that other song, right? That kind of direct evidence is pretty rare usually. And so instead, the plaintiff is allowed to rely on circumstantial evidence. And it's this circumstantial evidence of access plus substantial similarity that allows a court and the jury to infer and conclude that it must have been the case that the defendant copied, right? Why else would the works have been so similar? The defendant had access to the plaintiff's work and they're so similar, there must be the case that they're copied, right? Well, there can be other explanations. And, you know, for example, that's the way songs in this genre sound, or particularly in this genre at this time, or maybe even in this geographic area. That's the kind of music that was coming out of that area or that slice in time. And courts often say that the reason we entertain those types of rebuttal arguments is that, quote, independent creation is a complete defense. But I submit to you that the nature of that defense, it's simply a defense argument in rebuttal to the prima facie case. The burden of persuasion, that hasn't shifted, right? It's still squarely on the plaintiff to demonstrate that the defendant copied from the plaintiff's copyrighted work. Now, even more important, however, is the final element of the plaintiff's prima facie case of infringement, right? That the copying amounted to an unlawful appropriation. Important, right? This element is separate from the copying element, but unfortunately, we see litigants and courts collapsing the final two elements into one. So for example, in the recent Lizzo case concerning the song Truth Hurts, the songwriters cite a musicology report that concluded Truth Hurts duplicated, quote, distinctive elements from the demo that were unlikely to be coincidental. But based on the allegations made by the plaintiffs against Lizzo, we're beyond the stage of focusing on access and similarity. We're beyond the stage of asking about copying in that sense, right? Lizzo was present in the recording session that the plaintiffs point to as the source of their copyrighted work. And instead, we should be focusing on the fourth element, that the plaintiffs need to prove that the copying of just one line of lyrics is enough to constitute unlawful appropriation, right? That final fourth element. Or we see incomplete statements like the court in Gray versus Perry, where they describe the final element as a need to demonstrate, quote, that the defendant copied protected elements of their work, right? Gray needs to demonstrate not just that a protected element was copied, but that enough protected elements were copied amounting to an unlawful appropriation. So as the Ninth Circuit helpfully reminded us in the Rentmeister case, right, proof of unlawful appropriation, that is illicit copying, is necessary because copyright law does not forbid all copying. Right? Not only does copyright law not forbid copying of ideas and concepts, right, that's not infringement, but the court said, quote, to infringe, the plaintiff must also copy enough of the plaintiff's expression of those ideas or concepts to render the two works substantially similar. And it's plaintiff's burden to demonstrate this final element. So as to the final element, defense rebuttals take two forms, and they are largely legal rebuttals, right? On this last point, on the fourth element. The elements that are similar are not copyrightable, right? That's a legal argument about the copyrightability of different aspects of the work. And then the second sort of legal rebuttal is to the extent that some of plaintiff's protected expression may be present in the defendant's work, there's an insufficient amount of plaintiff's original protected expression in the alleged infringing work to amount to an improper or unlawful appropriation. So, and in this context, right, it's really important. We don't care if the defendant copied from the plaintiff's work. That analysis is left to element 3 for the copying prong. It should not play a role in element 4, the unlawful appropriation prong. And when courts correctly keep these inquiries separate and apply the burdens of proof correctly, we get decisions like the Rentmeister decision. And in the Rentmeister decision, the Ninth Circuit affirmed the dismissal of the plaintiff's claim for failure to state a plausible claim of infringement. Right? We're talking about a 12b6 dismissal. So I'm going to show you, I think if I can do this properly, I'm going to put up on the screen there the two images that were at issue in the Rentmeister case. So is that showing up well on the screen? Oh, good. Okay. So, right, this is a 12b6 dismissal. The court looked at these two photographs, right? It assumed all of the plaintiff's factual allegations were true, which meant element 3, the defendant copied from the plaintiff's copyrighted work, that was assumed proven, right? We're going to accept the allegations as true. But in the 12b6 context, the court was able to focus exclusively on that fourth element, on the unlawful appropriation inquiry, right? And again, the court said to prove this component of the claim, Rentmeister has to show that Nike copied enough of the photo's protected expression to render their works substantially similar. And proceeding under the Ninth Circuit's further rather unique bifurcation of the substantial similarity inquiry under what the Ninth Circuit calls the extrinsic test, the court noted that the photos can be broken down, right? They can be broken down into objective elements that reflect various creative choices the photographer made in composing the image. So choices about subject matter, pose, lighting, camera angle, depth of field, and the like. But none of those elements, the court said, is subject to copyright protection when viewed in isolation. So what's protected, the court said, is the photographer's selection and arrangement of the choices of these otherwise unprotected elements. Okay, so we think about choices that are made. I'm going to come back to you now as me, right? I think a similar analysis can and should be applied in music cases. Musical artists, both songwriters and performers, make a variety of choices related to their art form. They choose the words. The words themselves are not individually protectable. They choose the chords. The chords are not individually protectable. Time signature, pace, you name it, right? But none of those elements in isolation is subject to copyright protection. The combination of those elements, it's the choices made in the selecting and arranging of them that achieves protection, right? And this is consistent with what Reagan Smith was explaining in the last panel. And it's only when replicating a sufficient amount of those choices, not merely one or two, or maybe even a few components, that the similarities should be viewed as sufficient to permit a reasonable jury to conclude the plaintiff has satisfied its burden of demonstrating that fourth element of the infringement case, unlawful appropriation. Now, in Rentmeister, the Ninth Circuit acknowledged the two works share undeniable similarities at the conceptual level. But then the court went on to articulate the numerous ways in which the works were different, where different choices were made by the Nike photographer. And importantly, it was these differences in the choices made, as reflected in what the court called the photo's objective details, that precluded, as a matter of law, right, 12b6, a finding of infringement. So in other words, there was no way that a jury should even be allowed to hear the case, right? There was no way that a jury could permissibly conclude that Nike engaged in unlawful appropriation, even if Nike did copy from plaintiff's photograph. There was no way, right, on the facts alleged that the plaintiff could plausibly carry its burden, the Twombly-Iqbal standard that we use for 12b6 motions, right, plausibility. And similarly, I think in music cases, focusing on the fourth factor, the fourth element, right, of the unlawful appropriation, isolated from the third element, the element of copying, and encouraging consideration of both the nature of the similarities between the works and the quantity of differences in the defendant's work can help us really focus the analysis and allow us to use a phrase that Kevin Erickson used on the previous panel, right? Engage with the complexity of the fundamental question, right? Which is determining what should and should not count as an unlawful appropriation. So I'll end there and I look forward to questions.
Thank you very much, Lydia. Francis, we will turn over to you now. Again for joining us.
I appreciate it. First, this is the first time I'm ever doing this, so it's a little unusual for me. I guess everyone can see me. Am I big on the screen, or how does it work?
You are on the screen. We can see you.
Oh, great. Okay, great, kids. Look at you. That's it's funny. Anyway, I wanted to be in there in person. I wasn't able to. I'm involved in a very big case I've been working on for about 3 years and full-time, 7 days a week for the last, since October. It's imploding a global corporation in real time. I can't tell you who it is or which corporation, but you'll see about in about 2 to 4 weeks, you'll read about it. So I apologize not being there. You know, I think it's the whole copyright litigation, it's so skewed, and that no one really understands the reality is of how hard it is to bring a case to trial. everyone's acting and talking all this scholarly way, but who has actually taken a music copyright case to trial? Very, very, very few people. So you hear a lot about comparing this and comparing that and substantial similarity. And this is all textbook stuff. It's great. But until you've actually taken the case to trial, it's a very, very different world. And it's a bitter world, right? And it's sort of like I stand on that line like the Lord Commander, right? Between good versus evil. And it's that simple, right? You have the creatives and you have the industry. And the creatives are there to protect that which they created. And then you have the industry that all they care about is one thing, their dollars and cents and their bottom line. It's such a disproportionate playing field. It's so disgusting, right? That we're even sitting here having conversations about, oh my God, the floodgates of copyright cases. What's going to happen? And we're all buying into this. We're all buying into this sort of, this concept. We're talking about this idea, the floodgates. How many significant copyright cases ever get the verdict in the last 20 years? You can count them on your hands, right? We're not talking about a floodgate. People throw around terms like $1 million or $2 million. It is meaningless. How do you know that? Just look at the comparison, the disparity in income, the disparity in net worth between a songwriter who has nothing at all, and a global corporation, right, who brings in not millions, billions of dollars. All right, let's put this in perspective. The average songwriter makes how much a year? Nothing, okay? That's what he makes, the average songwriter. How about, that's the truth. How about the average American? 30,000 to 50,000, let's say. And you got tons that make zero and you got some that make a lot. So depending on how you factor in your average or your mean, it's going to shift. So 33 to 50,000. We'll use 50,000, okay? $50,000. That's not what a songwriter makes. They make zero. Let's talk about what Sony Music Entertainment makes a year. What do they make? $8 billion, okay? $8 billion. And they're talking about, they're concerned about $1 million. It's like a grain of sand in all the beaches in the world. It's nothing to them, right? So when we're talking about these things as if they actually matter, put it in perspective of the haves and the have-nots. You have a songwriter that all he's trying to do is get recognition for something that which he created. And then you have an industry that has the best lawyers, the biggest firms that will do everything to push him down, stab him in his back, and do everything to not give him a penny. And then what do? How does that songwriter even get to court? He has to find a lawyer who's crazy enough to take a copyright case to court. And how many of those are there? Very few. And how many of them that are successful? Even fewer. And how many of them actually tell their client, you know what? I believe in your case. So what I'm going to do is I know you have no money. You don't have really a roof over your head. Where you're at mom's house, your dad's house, sleeping with friends, struggling. So do you have the 150,000 just to get it to trial? No, of course he doesn't. So what lawyer or law firm is going to take this on a contingency and put in 150,000 and potentially, most likely, get zero in the end, and even 3 times that the amount of time and effort that went in? All right, hold on a second here. I don't know what my screen's doing. Oh, can you see that? Jesus, I hope not.
No, we can only see you.
Oh, good. Look, I've never done this. It has some email thing coming through. It's apparently telling me to buy a Desert Eagle. Great. It sensed my anger. Okay. There, I'm back. Okay, sorry guys. Let me get back to it. All right. You have these academics and you have these people like Algo Boy, the Geek Boy, the guy who did that algorithm. You know who I'm talking about, right? Who's trying to break down, yeah, I see you in the back there. You got the beard, longer hair, right? You understand what musicians go through, all right? You got Geek Boy, who's trying to destroy the most sacred part of music, which is your melody and harmony, and break it down to not even 12 notes. Forget all the other octaves. Break down to 8 notes. And then Let's just completely bastardize music as we know it and get rid of all duration of notes. All right? A T is always a T is always a T in the English language. How many letters are there in the English language? 26, right? How many notes are there? 12, right? Hey, no one's running out of books to read. No one's running out of books to write. You know, what's incredible is that in music, you have far more combinations than you do in the English language with 26 letters. Because you can have an A or B or a C, or whatever the note is, you can hold that for a quarter note, an eighth note, a 16th. How it modulates back and forth, the timing of the actual music changes it. He's breaking up 8 notes, making them all basically quarter notes, as if there's no duration in a note. So basically, he's limiting the scope of this of what they're actually analyzing to almost the smallest, minute comparison. It's meaningless. It's garbage in, it's garbage out. Geek boy, algorithm boy, losers. Okay, they're not there to protect songwriters. They're not. You know, and you know what? He can't tell that guy. He's never tried to case the verdict. All right. Look, let me make it really clear. I did this on my own. I did it by myself. All right. I represent the creatives against the industry. I've been doing this 11 years. I'm undefeated in jury trials. The 2 cases I lost, I overturned the appeals and set law. All right. That's an amazing, amazing track record. You got these people that want to talk about, oh, the difficulties in prosecuting the case and the burdens of proof. A plaintiff has an incredible burden of proof to show that he actually wrote something that they actually was stolen from him, right? The federal courts are going to be slanted to where? To the industry. They always are. It's just the way it is. It's a fact of life. Federal courts, whatever industry is in that community, whether it's the film industry, the banking industry, the insurance industry, federal courts are going to side with them. Oh, you're going to hear a lot about how the federal courts are the most fair courts and they're appointed for life and all this stuff. Not so, all right? The difficulties is, yeah, it's great if you're a defendant. It's great if you represent the defendant. But if you're actually representing the plaintiff, the creative, forget it. It's not a fair fight. We know that. Now, you have all these scholarly literary types talking about this nonsense about, oh, thin copyright. This drives me nuts, right? Let's be clear. The purest form of art is music. Not because I said so, because it is. Because Martin Scorsese said so. He didn't say film was. The purest form of art is music. Why? It evokes more emotion than any other form of art. How do we know that? Let me give you point in check. I went to Paris. You go, you look at the Louvre, right? You walk through. Have you ever seen? Raise the hands. Who saw the Mona Lisa? Okay. Did you cry? Were you like struck by its beauty? Did you drop to your knees? Did it throw you back to when you were 16 and your first date? Well, maybe not your first date. Maybe something more than that. 16. I don't know. Kids these days. You know, you're 16. Maybe you're driving your car. You're driving it fast. Look, the whole point is that you go by the Mona Lisa. You wait in this line. You walk by. And you're like, okay, big deal. Is that what that's about? It doesn't evoke the same emotion. Why is music the purest form of art, and why does it actually matter, and why should it not be given thin copyright? Because the beauty of music is that it's associative, right? If you read a book, all you do is read the book. You're sitting in bed reading the book. If you watch a movie, what do? You're sitting on a couch watching a movie, okay? It's not associative in that it doesn't intertwine with your DNA and your experience of life. But what does? Music does. What also does? Because you're all in Colorado, right? Drugs do too. You smoke weed. Colorado's big on that. Okay. Drugs are associative, right? They throw you back to times and places. This is what I read in the literature, the scholarly literature, right? You know, you remember the first time you got drunk. You remember your senior prom. Maybe you had some hits of ecstasy. I don't know. Okay. I don't know what the kids are doing these days. MDMA, Molly, whatever. Okay. The point being is that music is associative. That's why it's so compelling. It throws you back to a time and place. You hear a song, you go there, you feel it. You might shed a tear, right? You do music while you do other things. You be driving fast in your Mustang, posi rear. Maybe you got a slap shifter on it, 302, 5-speed, whatever it is. Doing burnouts. You're playing some Guns N' Roses. I don't know, okay? But the point is, you're at a senior prom. What do you listen to, Bob Seger or something? I don't know. The point is that they're associative. Why should music be basically chopped down to facts and thought about not in a way that's creative or that how it evokes emotion, but let's break it down to math and math magic and, oh, Algo Boy, okay? Point in check. No one will ever steal that Algo Boy's music. If you've ever heard it, it is the worst thing objectively. It's the worst music you could ever hear on the face of the earth. This man has nothing to worry about. I mean, it is like it's bleeding ears. It's embarrassingly bad. For him to say he even is a songwriter, a producer, or work with musicians, it's embarrassing, okay? It is so bad, it's actually offensive. And you hear it and you're like, oh my God, dude, no one's gonna steal that, okay? He has nothing to worry about.
Thank you, Francis.
Now,
We're gonna, if I can, we'll come back and give everyone a chance to respond. I wanna make sure we get time to let Kenneth respond or present his stuff, and then Richard, and then we'll circle back to the group.
let me just finish up this point.
Okay.
Thin copyright, okay? Music has never, ever been thought of in any way to be a thin copyright. It's full and broad copyright. It's the most complex of the art forms. It evokes more emotion than any other form of art. And for that reason, cannot be curtailed and minimized to be something so narrow as a thin copyright, right? And it never has been, it never will be. And for the industry and for even scholarly intellectuals to even try to really bastardize copyright law, to take protection away from songwriters and protect the industry, it's really disgusting, should never happen. I gave it to you straight, kids. There you go.
Thank you. Thank you.
No bullshit.
Kenneth.
I've been practicing law for 35 years. I've never had to quite follow that type of presentation, but I'm going to give it a shot. How do I come to this? I've had experience on the plaintiff side of this for quite some time. I also was on the defense side of the Thou Shalt Not Steal case. That was the sort of beginning of judicial hostility to copyright infringement. I have recently been hired by a group of musicologists. It's between 13 and 15, depending on which brief. So I've submitted an amici brief in the Blurred Lines case, the Led Zeppelin case, and the Katy Perry case. So I'm going to try and present on all three that kind of can weave it together, because it seems like these are the three big cases that are causing quite a stir in terms of the current music copyright community. We have a system. We've talked about the system, and we'll all admit as lawyers that it's not a perfect system, but it is the system we have. The copyright is based on statutes. The professor laid out the burdens of proof the way the courts have established it throughout the time, and that's the system that we have to live in. We also have a system with juries, and by putting a case before a jury, you're bringing in all sorts of elements, the credibility of witnesses, the experts, their credibility, and so what we find, what the musicologists find has happened recently is that many of the cases have gone to a jury, and it's become less about the math of the music, the actual music, and more about all kinds of other factors. And so what we tried to do in all three of these briefs is kind of rein it back. So I'm just going to kind of sprinkle my way through the three cases in the time that I have. The first case is the Blurred Lines case, and Richard will tell you about it. Richard won the case, and my hat's off to Richard for having done that. But the way I look at it, the way my clients have looked at it, is that there were two songs that were not similar. The melodies of the songs were different. The basic harmonies of the song weren't the same. So what happened was they hired a musicologist, and this is they refer to it as a constellation of similarities. Judith Fennell, who was the musicologist, presented this constellation of similarities. And it was a whole mess of factors. It was timbre, it was key, it was things that were other than what we believe are the fundamental building blocks of music, which are melody, harmony, and rhythm. And so what happens when a case gets to a jury, it means that it's survived the judge's, basically the judge has denied summary judgment. I don't know how many of you know what procedure is, but basically the case starts off and the litigators are going back and forth in front of basically a judge. And there's discovery and the depositions take place and there are discovery disputes. All of this is with a judge. And then at the end, for these cases, at the end of the evidence, when the experts have been deposed, when everyone's been deposed, a lot of times the defense and sometimes the plaintiff will make what's known as a motion for summary judgment. And the judge will basically be asked to say, there's nothing here to send to the jury. In other words, it's either the plaintiff's case is so overwhelming that we're just going to give verdict to the plaintiffs, verdict judgment to the plaintiffs, no jury needed. In the case of Blurred Lines, the defense made such a motion. And the appellate decision, which affirmed Mr. Bush's verdict, the main point that the amici were trying to make was that the judge himself, the judge is supposed to be a gatekeeper on these cases. But the reality is that, as we've heard before, judges don't know music for the most part, or they don't want to stick their necks out and rule on any music. Do they have a clerk that's a musician? Do they have a son at home that's a musician? I mean, where are they going to get their knowledge from? It's really difficult. I was happy to hear Sandy Wilbur say that she had been appointed as a court-appointed expert, and that's like 13 years ago, because one of the things that I've been saying is, and we really believe, musicologists, and I'll say I really believe as well, that Judge Cronstadt was required to make a decision. What he said in his ruling, and I don't have the language right in front of me, but it was something along the lines of, this expert opinion makes sense to me, this expert opinion makes some sense too. I'm not going to decide, I'm just going to send it off to the jury. But the judge is supposed to make, on the extrinsic test, which you've heard a lot about, it's supposed to look at the two experts and decide whether or not one of those experts is right or one of those experts is wrong. And the judge didn't do that. Now, for reasons that sort of go beyond the scope of what we're talking about here, the appeal which the amici focused so hard on was to say the judge made a mistake. You had to go back to the judge and make the judge look at this stuff. That summary judgment ruling was not appealable because of certain things that happened procedurally. So, you know, most of the amici role was kind of rooted in the Blurred Lines case. But suffice it to say that as I've been looking at the history of all this, I really believe that whatever made the judge in the court with Sandy appoint Sandy as the expert, I think there's procedures in the federal rules that provide that one can ask the judge to appoint a special master or a referee, or whatever you want to call it, in some way that the judge should admit, okay, I don't know this music stuff. I'm not going to just send every case to the jury, and I'll tell you why that's not a good idea in a minute, but I need somebody to help me make this decision. So I'm hopeful that in the future somebody at least tries that path. Because once a case goes to the jury, you run into a fundamental problem, which is the jury, the oral representation of what the jury hears has just too much weight. And switching ahead for a minute to the Led Zeppelin case, if you hear those two guitar parts, and you hear it played by guitar, and it just sort of sounds like, oh my God, it sounds the same. But when you break it down musically, all that's similar there is bum, 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 just a descending bass line is basically what it boils down to. And in that case, the jury, I believe, got it right, that wasn't enough because that descending bass line is all over the prior art. Francis was successful in getting the case overturned because the judge didn't instruct about selection and arrangement. And then now that the Led Zeppelin case went up en banc and the amici put in a brief, and I just want to quote a little bit because one of the things that we cited in the Led Zeppelin brief en banc, which is something that I commend you all to read, is the dissent in Blurred Lines that Judge Nguyen wrote, and I'm just going to read some of that. She said, the experts' cherry picking might be reasonable if the two constellations bore any resemblance, but Big Dipper and Little Dipper they are not. The only similarity between these compositions is that they're both compositions of stars. What she meant by that is, yes, the expert, who was Ms. Fennell, threw together this panoply of unprotectable elements, timbre, cowbell, melisma, I think she called it. But the melody, harmony, and rhythm was different. One was ba 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 ba. One was bum 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 bum. It's really not the same. And I know that in the courtroom, I'm sure I wasn't there. Ms. Wilbur probably had a keyboard sort of like this, but I'll spare you the sounds, and played it in that way. But in the Blurred Lines case, because it was before a jury, and again, I wasn't there, but I'm sure that Richard did a phenomenal job of portraying the untrustworthiness, if you will, of the witnesses, because as many of you maybe have read, both Robin Thicke and Pharrell Williams were kind of giving the finger to this whole process, and Robin Thicke said some things to the press that were regrettable, and so as a jury trial matter, it became about a lot more than whether the music was substantially similar in that particular case. In the Zeppelin case, there is an appeal en banc which is pending right now, and yes, the thin copyright is a big issue there, and basically what a thin copyright means is if you don't have copyright of melody, harmony, rhythm, of things that are protectable, and instead you have a panoply of unprotectable elements, there are cases in the Ninth Circuit where those unprotectable elements can, in and of themselves, create an infringement, but the copyright is thin because it's a grouping of unprotectable elements, so it has to be virtually identical. And so the case that I'd commend you to there is Satava versus Lowry, which held that a selection of clear glass, oblong shroud, bright colors, proportion, vertical orientation, the stereotypical jellyfish form, all considered together lacked sufficient originality. It was not virtually identical between the two pieces of glassware. And contrary to what Francis just said, I think there's no reason whatsoever that a copyright in a musical work should be different from a copyright in anything else, which is what was argued in the en banc. The ruling's going to come out in a few months. I'd like to think that that's where it's going to end up, but there may be other issues in that case that prevent the court from even going there because of the way that appeal is set out. Now, the one that's in front of the court right now is the Katy Perry case. And what happened in the Katy Perry case is the jury found infringement and $3 million worth of damage. And basically all we were talking about in that case was, that's what's similar. I don't know if you could hear that. Those were the two things that were similar in the Katy Perry case. The plaintiff argued that pitch sequence plus the fact that the rhythm of the notes was the same, and that was the rhythm of the notes. Bop, 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 bop. I mean, we probably all can, there's so many songs that have that rhythm that I can't even begin to tell that, to state them. The timbre was the same. Now, the timbre is a sound. The timbre should not even be part of the music copyright because that's part of the production, but yet that was included. The phrase length of the eighth notes, which again is another way of stating the rhythm, and the placement of the ostinato in the sound recordings mix, the ostinato being that repeated figure. And so what happened there is that the defendants have made a motion for, I think it's for a directed verdict, essentially a judgment notwithstanding the verdict. So in other words, the judge is being asked basically take that verdict away from the jury and direct it in favor of the defense. And the main issue there being that it's a thin copyright and is not virtually identical, and therefore that should be reversed. Now, I just want to, I guess I have a minute or two. I just want to respond to a couple of the things that Francis said. The first thing is, it's really not the creators versus the industry in these cases, because as you heard from Sandy, and as I can tell you from my own experience, it's the creators themselves, the songwriters themselves that are freaking out over this. And it's songwriters that are making $0, songwriters that are making $1,000, songwriters that are making $1 million. Because the fact that these three juries could come out the way they did, which seems so musicologically incorrect, is very scary, that these cases can happen. And so what we're at least trying to do in the Katy Perry case is to stop that trend when you have these sort of inconsequential similarities, and make sure that there has to be virtual identity. And I think that rule is also at play in the Led Zeppelin en banc. So we stay tuned to see how the law might get refined as the weeks and months go on. I think that's
Great.
pretty good.
All right. Well, Richard, we'll turn it over to you.
So
Thank you again.
As you might imagine, I have quite a bit to say about what's been said by everybody. I'll start, I guess, with this, that in the Blurred Lines case, we had his amicus, Ken's amicus. We had 21 musicologists who filed an amicus saying it was absolutely a copy of Marvin Gaye's Got to Give It Up. So this idea that Ken is proposing that the law should be a certain way, or that music is understood to be a certain way as far as what constitutes copying of a composition, there are, even within the musicology, I'd say, industry, or the musicologists that are at universities across the country and across the world, there's great disagreement. So yes, we had the amicus brief by Ken and his musicologists. We also had 20 of the greatest musicologists in this country, in fact, some of the greatest musicology minds in the world, saying it's absolutely a copy. So the question becomes, what do you do with that? Do we have one person picked by the judge make a decision? No, it's not the way it works. When you have differences of opinion, the Constitution, the Seventh Amendment, says a jury will make the decision. And let me tell you something else. Judges have prejudices. Judges want to get cases off their dockets. One musicologist may have an opinion, but that is not the opinion that counts. The opinion that counts is a jury of your peers deciding what constitutes copyright infringement. And the first speaker said we should be looking at things that are different. Judge Learned Hand said 50 years ago, an infringer cannot avoid liability by showing that which he did not copy. Okay? And this idea that if you take a line, a vocal line, that cannot be enough. I think there was a comment about the Lizzo case, and there was a question about line. That case is actually a little bit different. Because there's other issues involved. There is issues about whether she was a co-writer on the original song. If you're a co-writer, you can't be sued for infringement. There's a question about whether the plaintiffs actually waived their rights in that case. There's all kinds of issues involved. But one line of a composition can be very important. One line of a composition can be very important. I'm going to talk about blurred lines a lot and the disagreements I have with virtually everything Ken just said for the last 15 minutes. But I do want to mention one thing in particular, because Dr. Stewart is here, who actually, and I think he spoke earlier, Dr. Stewart and I worked together in another lifetime, back at the Bridgeport days. And I tell this story all the time, and it's one of my favorite stories. And it's relevant because of what Lydia said about a vocal line not being enough. So I filed in the year May 4th, 2001, a day that will live in infamy, I guess, to some, 478 copyright infringement cases against the entire rap music industry. And I call it the Entertainment Lawyers Relief Act of 2001 because every entertainment lawyer in the world had a piece of that case. And I was a kid. it was the beginning of my career pretty much. I didn't know what I was doing, but I filed them. And I remember sitting in a courtroom in Nashville, Tennessee, with virtually every lawyer at every major law firm across the country, in New York, Los Angeles, everywhere, and me, just me, sitting there. And they were all telling the judge how ridiculous these cases were that I just filed. And one of the lawyers from Mitchell, Silverberg, and Knupp stood up and he said, "Let me tell you, Judge, how stupid and idiotic these cases are. He said, Mr. Bush just sued my client because my client used the word dog in a case, in a song. As if Mr. Bush and his clients own the word dog. Now, this was the use of George Clinton's song Atomic Dog, and there were two pieces that were used. Bow, wow, wow, yippee-yo, yippee-yay, and the word dog. And in Atomic Dog, the word dog ends each sentence. Dog, dog, like that. And in the song that copied it, Dog and Me, it did the same thing. So I remember sitting in a hotel in the Embassy Suites, I think, in Franklin, Tennessee, with Alex years later when we were preparing for the case and working on things. And we said, you know what we should say? And I don't know if it was Alex's idea or mine. Probably I'll give you the credit, Alex. And Alex and I said, one of us said, what we should say is that it's the unique use of the word dog. It is used as musical punctuation in Atomic Dog, and it's used as musical punctuation in Dog and Me as well. And therefore, it is an original use of a non-original word, and therefore, because there's no other song that uses it in that unique way, it's copyright infringement. And we won. And the Sixth Circuit then affirmed that decision, finding that a unique use of a non-original word, even a short word, a word like that, that's not original, can be copyright infringement. And Billboard magazine identified that in New York Times as one of the most important copyright infringement cases of the year, which was 2009. But that's a good example of you can have short, small uses. Because remember, the test is whether it's quantifiable, qualitatively or quantitatively important. So it can be quantitatively important or qualitatively important. You can think of small uses of songs that are quite recognizable, that if copied, should be copyright infringement. So there are all kinds of different opinions on what constitutes copyright infringement. I've heard it here today. But what Ken said and what I've heard is not the law. Simply as that. So if you all are familiar with the Ninth Circuit decision in Swirsky and in Three Boys, those are two cases that the Ninth Circuit, is the Ninth Circuit law. Blurred lines follow those cases to the letter. Judge Cronstadt followed those cases to the letter. And what Swirsky says is there's all types of compositional elements that make up a composition. And there's a list. If you read the case, I'm not going to repeat it here, I don't have the time, but it's all kinds of things that make up a composition. Not just the main melody, not just the things that Ken would suggest make up a song. All kinds of things make up a song. And if the plaintiff can show misappropriation of substantial elements of those types of compositions that are substantially similar, then he's set forth or she has set forth a copyright infringement claim. And in Three Boys, and the court also said there's no magic formula. There's no magic formula. And in Three Boys, it was sort of the same analysis as Blurred Lines, but I think much weaker. There were 3 or 4 or 5 elements total, and I believe 3 were not in what was recognized by the lead sheet. I'll talk about the lead sheet very briefly in a moment. But the court found that combination, the unique combination of elements, even if not independently original, can constitute copyright infringement. So that is the law. I agree with Francis absolutely 100% on the thin copyright. Let me tell you what thin copyright is meant to protect. Thin copyright is like you paint a tomato. There's only so many ways to paint a tomato. That's a thin copyright. There are millions of songs, all different. That's not thin copyright because it's creative. There's different ways to do it. And so this idea, and I don't think the Ninth Circuit is ever going to find that this virtual identity thin copyright thing flies. It's a crock of shit. Okay, it really is. Like I said, it's about when you paint a basketball or a tomato or something like that. There's only so many ways to do that. So that's what thin copyright is all about. On Blurred Lines, since Ken went after Judith a little bit, I'll note this. It was part of the melody. So there was vocal melodies that were taken. There were 15 different elements that Judith Fennell had identified, not 5 or 4 or 3 like in Three Boys, but 15 different elements that Judith identified that were copied. Vocal elements. There was a combination of the bass line and the keyboard playing together. The notes did match. There was also something that she identified that was really brilliant. And by the way, in Swirsky, the court says that structure, the same structure, is a relevant factor. And in Blurred Lines, there is a rap section that begins, I think, at bar 82 and ends at bar 120. In Got to Give It Up, Marvin Gaye's song, they have a spoken section of that song that begins the exact same bar and ends the exact same bar. In other words, there's no doubt that Blurred Lines, that Got to Give It Up was used as a blueprint for Blurred Lines. Now, it's true that there is more to a copyright infringement case than just music. There's no doubt about that. And there's no doubt that it should be, because things like independent creation and willfulness come about. And importantly, I think I'll mention something to you. I don't know if you have paid attention to this, but this is why juries are the right places for these cases, because they want to do the right thing. They want to find justice. There's no doubt about it. I'm not sure judges do. Certainly a musicologist paid by one side or the other may not want to, but jurors do. So Pharrell Williams in Blurred Lines testified under oath that neither Marvin Gaye's Got to Give It Up nor, neither Marvin Gaye nor Got to Give It Up ever entered his mind while creating Blurred Lines, despite the fact that Robin Thicke said before trial that he told Pharrell to create a song just like Got to Give It Up. He said that was not true. Well, Robin Thicke said he was drunk and high, so he didn't know what he was saying, or he was saying it was meant for promotion and he was lying. But in any event, Pharrell Williams said neither Marvin Gaye nor Got to Give It Up ever entered in my mind when creating Blurred Lines. The judge relied on that testimony in denying the Gaye family fees. About 3 or 4 months ago, maybe 5 months ago, Pharrell Williams gave an interview in GQ magazine where he was being interviewed by Rick Rubin, and he said that when he creates music, he reverse engineers songs that did something to him emotionally, and that he tries to create that same feeling in another song, and that he did that in Blurred Lines and got himself in trouble. And he said, I made Blurred Lines feel so much like Got to Give It Up that people thought they heard the same thing. Directly contrary to his sworn testimony at trial. We've gone in under Rule 60 now, and we've asked the court to find that Mr. Williams committed perjury, and we've asked the court to reevaluate the issue on fees. And the reason why I mention that is because the result was the right result. The result in Blurred Lines was absolutely the right result. There are 20 musicologists who submitted amicus that say it was, and it fit right within the Ninth Circuit Swirsky decision. I would be remiss if I didn't mention the lead sheet issue very briefly. I've heard that it's been discussed here a little bit, and I just want to touch on it very briefly because it was my case, the Blurred Lines case, where that decision was first announced. And I feel bad about it because the judge in the Torres case, which Francis litigated, followed it, and that's one of the reasons Francis lost that case was because at the district court level was because of the lead sheet issue, and it is a ridiculous decision, just legally and practically. I don't have time to walk through why legally it doesn't make sense. I mean, basically, the 1909 Copyright Act says specifically that copyright protection extends to anything from which music can be reproduced, which certainly is a sound recording. And the Judge Kronstadt's decision was based on a tortured reading of a 1997 amendment to the Copyright Act that doesn't hold water. But from a more fundamental reason, it doesn't make any sense. Marvin Gaye created Got to Give It Up in the studio, right? He didn't sit there and write sheet music. He created the song in the studio while he was playing it. The composition, and by the way, in that same case that I was mentioning with Alex that he and I did, the court even said, the way modern music is created, the composition, the sound recording are essentially the same because the sound recording embodies the composition. You can make some arguments about performance elements, but essentially the composition is what is within the sound recording. That's why the Copyright Office now accepts the deposit copy being a recording of the composition, number one. And number two, there's no doubt in post-1978 cases that the sound recording is relevant to be the best evidence of the composition. So there's several reasons why this ruling is ridiculous. Number one, we would have different rules depending upon whether a pre-January 1, 1978 composition is being infringed. In those cases, you couldn't play the sound recording, but in the post-78 you could, because one's under the 1909 Copyright Act and one's under the 1978 Copyright Act. But even more fundamentally, here's the issue. You're disenfranchising the songwriters who don't know how to write sheet music from what they created. So no longer is Marvin Gaye or any of the great Motown writers the authors of those compositions. It's some after-the-fact transcriber who knows what their education is, who knows what their ability is. They just were, because the Copyright Office did not accept anything other than written notation as a deposit copy prior to 1978, they had to have some sheet music prepared. They prepared a lead sheet that basically was a skeleton just to get the copyright on file. So you're taking all of these works, these pre-78 works, you're disenfranchising these writers from what they created, and you're saying that the after-the-fact transcriber is now the author of some of the greatest songs of all time. You're basically allowing someone now to go to the Copyright Office, check out what's not on the lead sheet, and say, now it's public domain. Now I can copy it for free. And everyone's worried these days about what this means to new artists, but what they're not thinking about is what this means to artists of a different generation who rely on their music to live. And I know I'm out of time, but it's just important to keep in mind that there are policy reasons at play here as well about why this lead sheet issue should not go the way I'm hoping it does not go.
Thank you. That's a really good point to make. Thank you for thanking our panelists. I want to, given our timing, turn it over and make sure we have time to get some questions from the audience before we go and have our reception. As the other panelists have done, we'll start with a question from the students. So if there's anyone in the room who's a student of any type, you don't have to be a law student, please raise your hand so we can start off with you. In the back here.
Okay, I think we can all agree that copyright law doesn't aim to protect ideas, only the expression of ideas. In cases like Gray v. Perry and Skidmore, where there's arguably less original expression at issue than the blurred lines case, if there's no such thing as a thin copyright in music, as some of you were saying, and some of you were saying that you don't believe in dissecting music into its constituent elements, how do you think the court should distinguish between ideas and expression?
That's a good question. That's a very good question. And my answer to that is several things. And that's one thing I wanted to mention, actually. So as was mentioned earlier, it's very difficult, and I agree with Francis on this, it's very difficult to set forth a viable copyright infringement claim. It really is, because the defendants will raise things like prior art. So remember, it has to be original, and there has to be no prior art. It has to be original, so that means what the defendants will do will come in and bring in all the prior art they can to show this is not original expression. So to your point, if it is a basic melody of a few notes, which is what Ken was playing on his piano for us a moment ago, you would think that the defense would be able to come in and say, and I believe Ken said, there's so many songs that are just like that it can't be original. Well, what will happen is they will come in and they will show that to the jury or to the judge, and if they're right, they should get a ruling in their favor. In Blurred Lines, for example, the defendant said that this is just a genre or an era. It's not the copying of the actual composition. But guess what? They couldn't come into court and show actual songs that had that same the same melody, the same parts that were used. So to Ken's point, if they can do that, that's where, in my mind, that issue arises, where you have to show that it's important, you have to show that it's part of the composition, and you have to show that it's not unoriginal. And if they can show prior art, that will help them defend against the case.
You know, I just want to add one thing to that. In the Katy Perry situation, we actually found, not quite like the database that Francis was talking about, which I also think is kind of suspicious. There is something called Theme Finder, and there's something else called the RISM database. And so, for instance, that was found more than 2,000 times in the RISM database, and many times in the other databases as well. There are databases of prior art, and some of the musicologists themselves have access to prior art databases. If it's there, it's there. I agree with that the Blurred Lines case is a little bit different because there's more going on there, and there wasn't going to be something necessarily that was going to be just like that.
I'll just take a minute to remind Lydia and Francis, you guys can jump in. We can hear you if you want to contribute anything on a question.
Yeah, my thoughts is this. First off, Richard, I was hoping to meet you in person. We talk on the phone sometimes, so nice to be in this conference with you. I heard Alexander Stewart's there also a brilliant musicologist. So hello to all. For the kids out there, it's really neat because you have the two best trial lawyers in the country who are in this conference with you. So good for you. You should ask lots of questions. There's a wealth of knowledge that you'll never get, and it's a very unique thing. You really don't understand that until you actually, well, maybe you guys will graduate, maybe you won't. Maybe you'll pass the bar, maybe you won't. Most likely.
You will.
Most likely. No, honestly. Most likely, none of you will see the inside of a courtroom. You'll be stuck in a cubicle doing workman's comp or some sort of defense work. But if you are lucky enough, maybe you can champion these types of cases. Here's what's great about a jury trial. You have the great equalizer. The great equalizer is the jury. The jury is there to make sure there's a fundamental fairness. And look at Richard's case. You can say, oh, this was more feel or groove. The jury got, no matter what, if you think there's less expression in the Blurred Lines case, it doesn't matter. The jury got it right. Why? They did a preemptive strike and tried to sue the gay estate preemptively, and it backfired on them. It's exactly what was supposed to happen. So putting that aside, look, there's no formula. It's not a mathematical formula to figure out what copyright infringement is, right? And it makes it so hard to get in front of the jury to prove your case. But let me talk about a little, like Ken really bothers me. Okay, I'm gonna tell you why. He talks about, oh, it's these songwriters. Now I'm gonna call them out. It's these songwriters that actually are really concerned about this, and they file these amicus briefs in Led Zeppelin. You know what? I analyzed this. I couldn't believe it. 123 songwriters. Do you know what their average wealth was? $4 million. These were CEOs and the top people at the industry. This was not the songwriter who doesn't have anything. These are people that had millions of dollars. Their average net worth of these individuals was higher than anything you could ever imagine, more than anyone in this room. All right. And so when you're talking about, oh, these songwriters that supported Led Zeppelin, it's industry shills, it's disgusting people who do not represent the creatives, but represent those who have a lot. The songwriters, the 1/100th of 1% of songwriters who actually make money writing songs, who are the industry. So let's not be confused with that issue. Second issue, there's no floodgates opening up. There's not a lot of lawsuits that are happening, right? It's very, very few and far between. When you look at slip and falls, there's thousands, hundreds of thousands. When you look at medical malpractice, there's hundreds of thousands. The industry pretends like there's some concern, but all there is a few cases that ever get to the jury.
Great.
And the real sum effect of that is very, very small. And the jury generally gets it right. Even in our case, the jury got it right. They had a bad comparison. If they listened to the audio, we would have won. But the jury got it right because they were given a bad thing to compare.
Thank you. Thank you very much. We have another question here on this side. There's a mic coming for you. Thank you.
Hi, I'm Professor Plum. I know everyone will now remember that. I teach music business at CU Denver. We talk about this case a lot, and this is primarily for Richard.
Which one?
What's that?
Which case?
The Blurred Lines case. And what I've explained to my students is that the jury was not allowed to listen and distinguish between the two recordings. And I think that sometimes is confusing for students to understand that. I was just curious if you could expand on that for the students in the room to understand why the jury wasn't allowed to listen between the recordings.
Sure. So that allows me to say that I'm the only one who's ever won a music copyright infringement case without playing music at the trial. So, but it's a joke. But it is true that we cannot play Marvin Gaye's song at trial. So the reason why was because of the lead sheet issue. So what the judge said was that so Judith had identified 15 different elements of Got to Give It Up that were copied in blurred lines. The judge before the trial said that only 4 or 5 were actually reflected in the lead sheet based upon Judith's admission that was the case, and what Sandy Wilbur, who's here also, who was the expert for Pharrell and Robin Thicke, said was reflected by the lead sheet, or at least arguably in the lead sheet. Maybe Sandy disagreed with Judith on that, I don't remember. But the point was that the judge said that as a result of that, we could not play Marvin Gaye's song because to do so would be to expose the jury to elements that he was finding were not relevant because they were not reflected in the lead sheet. So it would be prejudicial to the defendants or the plaintiffs, because they did file the case, that is true, to allow Marvin Gaye's song to be played. But in a weird way, I have to admit that I believe, in my mind, in a weird, perverted way, helped us. And the reason why is because if you listen to the totality of Marvin's song and the Blurred Lines song, there are parts that sound, people will say, the same. There were parts that are admittedly that don't sound the same. And so if we played both songs, you could be distracted by what's not the same. What we were able to do, what the judge allowed us to do, was to make little clips of the parts that we said were similar and that he found were reflected by the lead sheet, and play those clips right next to each other, focusing the jury on the parts that were arguably very similar, if not nearly identical, and that sounded as such. And that, in a weird way, at the end of the day, although when he made that ruling, when he made the lead sheet ruling, I'll tell you, this is important. So I think you'll like this story. So the judge made the lead sheet ruling literally on the eve of trial, and said we could not play Marvin's song like 2 weeks before trial. So I had to call Jan Gay, that night, and I said, Jan, let me tell you what just happened. And Nona was on the phone, and Jan was on the phone, and I said, the judge, and after that ruling came out, I got a phone call from my opponent, Howard King, and Howard said, Richard, you know you can't win this case. He said, you can't play Marvin's song, you can't compare the two songs, you're going to lose, and let me tell you what's going to happen. The Gay family doesn't have much money. They rely on their royalties to live. And what's going to happen is, I know this judge, we're going to get our attorney's fees imposed against you because we're going to win. We have over $2 million in attorney's fees, and we're going to get that award, and we're going to garnish all the Gays' money from all their royalties for the foreseeable future, because they don't make that much per year. It's going to be for years. They're going to be homeless, they're going to be destitute, and it's going to be all your fault because you didn't settle the case. So I called Jan and Nona, and I said, this is the decision we got today. We can't play Marvin's song at trial. And this is what Howard tells me is going to happen. This is what his threat to us if we don't settle right now. And Jan paused for a second. She said, let me talk to Nona, and we'll call you back. So I hung up the phone. 30 seconds later, the phone rings. Jan's back on the phone. And she says, Richard, Nona and I talked about it. We have faith in you. You can win this case. We're not giving up. I thought, fuck. So
you said you got to give it up.
So I went to my room, turned off at the hotel, the Doubletree, downtown Doubletree, turned off all the lights, got in the fetal position, was sucking my thumb for a while. Then when I was able to come out of it, I thought, I got to win this case. I can't lose this case. And I think Howard's problem was he thought it was over, and what he didn't realize it just begun. And so I decided what we needed to do was make it so that no jury, no matter what, would rule against us. And we used, as Ken says, we used everything we had at our disposal. All of Robin's statements, all of Pharrell's statements, and Judith prepared these clips that were unbelievable and that made our case for us, and we won.
Thank you. Well, I see that it's 5 o'clock. We have drinks and snacks waiting for us in the room next door. I hope you will all join us to continue this conversation. Thank you again so much for being here, and thank you for all of the panelists. Thank you very much. Thank you, Lydia and Francis. We wish we could raise a toast to you. You'll have to go have your own drink without us.